ain't never popped a Mari, but if I ever catch Mac, I'ma pop a Holly. I don't even rob a cop the Harley. Blowing so much green, I shame Marley. Yeah, I push the line to its full limit. Hit the hole like 22, boy, I'm a young Emmett. Nothing go like snow, now that's a cold image. Still whistling, sending, knocking them white women. Only reason I do it to avenge Emmett. To the day they go before and they box me out. Knowing me, it don't matter, I simply change my route. On my hobby.
And he came.
Salute. We finna pull it up for y'all right now.
We're gonna get into that first, and then I'll read. I'm gonna read the Big U paperwork. Then I'm gonna do another video, and right after, and I'm gonna read
pull TJ up.
Objection to Big U's position, and then tonight on the live, we're gonna get into both. Both down. Let's go. Y'all be sure to hit that like button. You know what I'm saying? And then tonight, we're going to get into both. Both down. Let's go. Y'all be sure to hit that like button. You know what I'm saying? And then tonight, we're going to get into both. Both down. Let's go. Y'all be sure to hit that like button. You know what I'm saying? And
why am I getting feedback? Hold on, that's all.
Tonight, we can live. Get into both.
I don't know why it's like this, but we finna fix it. Technical difficulties. Just know we got the content, so we gonna turn that off. I think I'm in too many places. Hold on, let's cut some of this shit off. We gonna close all this shit. Hold on. Boom. Let's close that. We can leave Instagram. There we go. Now we gonna open it up. Wack 100 Imam. No, that's not it. Boom. Y'all gotta bear with me if y'all on Lamonte Sims on YouTube. Let me see. My bad if y'all on Clubhouse. I know y'all can't hear it, but we finna get y'all the audio, but we was having technical difficulty, but we got the content. Yeah, I don't know what the hell is going wrong.
We're going to get into both. Both down. Let's go.
Where they at? Can y'all see me on StreamYard? I don't know what the hell is wrong, right? Oh, I know what's wrong. It's on active chucks. Damn. I'm slow. Hold on. Oh, shit. I'm uploaded on active chucks, and I'm showing this, and I'm like, I'm having technical difficulty. JJ, what up, bro? We got Pops up in here. Okay, here we go. We finna fix it right now. My bad, man. We got the video, and then here it goes. Bam. Now we finally got it. Damn.
Extortion.
Y'all ain't missing nothing yet.
Saying that a lot of this stuff that y'all have put together doesn't even say anything. It's just a big group of stuff that doesn't even connect to the actual charges. He cites Rule 404B requiring a disciplined item by item propensity free chain of reasoning, not a thematic narrative untethered to particular proof. Basically saying, hey, if y'all gonna have this stuff mentioned in my overt acts, then there needs to be some particular proof that ties me to these overt acts. Otherwise, y'all just throwing a bunch of allegations out there.
You don't know what
I agree. I totally agree with Big U's argument as articulated by one Byron.
Hey, I just started eating.
Way to make sure you get that up out there like that.
Is overt act number 150.
So this overt act number 155, this is what he's showing. It says on December 30th, 2022, on an intercepted call, defendant Henley said that when defendant Henley catches Wack 100, I'm gonna break his jaw. Defense response: this is a private statement of frustration, not a threat communicated to Wack 100. There is no evidence Wack 100 ever heard this statement, was placed in fear, or was harmed. The government has not charged any assault on Wack 100. Right? Let's go.
5, which alleges that on December 30th, 2022, on an intercepted call, defendant Henley said that when defendant Henley catches Wack 100, I'ma break his jaw. The defense response to this is a private statement of frustration, not a threat communicated to Wack 100. There's no evidence that Wack 100 ever heard this statement, was placed in fear, or harmed. The government has not charged any assault on Wack 100. He would also include overt act number 164, which alleged that on January 12, 2023, on an intercepted call, defendant Henley said he wanted to beat the out of Wack 100.
Now, let me clear this up and clarify this before we go. Because he misunderstood the overt acts as it pertains to the arguments about what's going to be admissible, what's not going to be admissible, and in this motion, that does not lead me to believe or to change my position that Wack 100 was a third-party cooperative, that Wack 100 facilitated open source intelligence, just ChatGPT open source intelligence, right? That would be used, and you're going to see in the paperwork that they are actually arguing to use Wack 100's interview that he pushed for, that he facilitated on No Jumper with Loose Cannon. So I do believe that Wack 100 is a cooperative and working for the means through Dale Morrison, through Loose Cannon, through Molly Mall, and others, and utilizing his position in other platforms, DJ Academics and Vlad, to publicly attack him, antagonize him as an agent provocateur. Let's get to it.
The defense response to this is the government has not identified what action, if any, followed because none did. Expressing disapproval of an informant in a private conversation is not obstruction of justice, witness tampering, or a RICO predicate act. The government must prove a specific criminal act, not a cultural attitude. In support of this, Big U would argue that the government may rely on the proposition that in conspiracy cases, it may prove the full scope of the conspiracy. That proposition, however, does not mean every uncharged act connected in some way to an alleged conspiracy or enterprise is automatically inextricably intertwined.
So basically, everything has a statute of limitation, but that's not what the Assistant United States Attorney is arguing, and we're going to get into that also, right? There has to be some kind of guardrails from allowing anything that the government argues as material evidence, which would prejudice and prevent Big U from getting a fair trial. Let's go.
Basically saying that every single thing that we done, all of this stuff that we not even charged with, is not automatically a part of the conspiracy or, you know, an extension of the conspiracy because y'all alleged that a conspiracy was going on at the same time that this was going on. Critically, even in the RICO,
let's ping up on Clubhouse.
The government must make an affirmative.
We did it again.
How proof of each incident it seeks to admit constitutes proof of the scope of a charged conspiracy to avoid a Rule 404B analysis. So when you talking RICO cases, to avoid this 404B scrutiny, you have to show how all of these affirmative acts constitute proof of what you are charging us with. You know, if you got a overt act saying, you know, I threatened to break Wack 100's jaw, then you need to have a thoroughly presented breakdown that shows how this is proof of what I'm being charged with. Where the government seeks to introduce uncharged acts that are not alleged in the indictment as predicate racketeering acts or acts in furtherance of the conspiracy and fails to provide 404B notice, the court should exclude the evidence. So he's saying, hey, if these acts are not, if we not charged with this and they not saying that this was done in furtherance of the conspiracy or that it's not an actual racketeering act, then y'all should not allow this in. And in closing on this paragraph, he said,
and I believe that that's, hold on. Well, shut up. No, they finna, I had to go get the dog. But no, I do agree. But this is something that you guys got to be able to understand and differentiate. In a standard conspiracy, evidence is generally limited to the specific agreement and the overt acts performed to achieve its goals. While RICO's, CCE's, continual criminal enterprises, and traditional conspiracy cases all follow the standard federal rules of criminal procedure, RICO and CCE cases involve specific procedural and evidentiary superpowers that aren't typically available or used in mere conspiracy cases. So this is where dumb truck attorneys, like the ones representing Big U, they up against it. So let's start from there. They're up against it, but this is where they fall short. But at the same time, them raising it preserves appeal rights, and also it makes the judge, it forces the judge to ensure that he has a fair trial, and makes him put some guardrails to protect his constitutional rights to fair trial. But let's get back to the video, and then I'm gonna break down the Big U motion.
Is that where uncharged acts are sufficiently disjointed from the charged pattern of racketeering activity, they cannot be deemed inextricably intertwined and must be subjected to the strictures of Rule 404B. Furthermore, the use of uncharged acts to prove a RICO conspiracy raises acute jury instruction and jury unanimity issues, making it hard for the jury to be unanimous. And as the jury may properly rely on non-predicate overt acts to reach a verdict. In other words, when you're bringing in a bunch of stuff that we haven't been charged with,
most people think that you need
Damu
$200,000 in 2 years of business.
Conversation. Let's bang that like button. Hold on. Investment banking. I'm going to show you better. Hold on. Why back by hundreds of reviews, sites like Google, Trustpilot, Yep, built you a career. Real experience. Man, I'm thinking that was something about venture capitalists. Let's go.
Fuse the jury and have them relying on something that we haven't been charged with as just an overt act. And they may end up finding us guilty on that. Now, the government would respond to Big U, and they would say that the fear and control category encompasses charged overt acts that are direct evidence. They would go on to say the defendant's motion challenges dozens of overt acts alleged in the first superseding indictment, styled as Rule 404B concerns. That framing is backwards. The government is entitled to prove the overt acts charged in its own indictment. These are not uncharged other acts. They are part of the charged RICO conspiracy, and proof of charged overt acts requires no 404B justification. Now, the reason I was emphasizing uncharged in the last stuff that I was reading from Big U is because I was seeing that they were locked in on that. He kept saying, y'all saying I threatened Wack 100. I'm not charged with that. Y'all saying that I said I wanted to beat up Wack 100. I'm not charged with that. The government is now coming back and saying that, yes, you are. The fear and control category that Big U is talking about encompasses charged overt acts that are direct evidence. Again, it says these are not uncharged other acts. They are part of the RICO conspiracy, and proof of charged overt acts requires no 404B justification. So, long story short, Big U is charged with assaulting Wack 100. It says it right here in the paperwork. He mentioned Wack 100.
No, if it was charged, you'll see it at the top right of the indictment, right? Those are the charges. The overt acts are being argued because it's a RICO case. So if they could first prove, remember, Puffy had a RICO case. If they could first establish a criminal enterprise for RICO and then prove overt acts in furtherance of this enterprise, each one of these, he could be held accountable or liable for the actual crime of, if it's a murder, 25 years to life. I believe that's what it is in the feds also. Maybe it's 360 months to life, right? If you're going by the United States sentencing guideline. Or if it's a gun, up to 5 years or whatever, right? So this is where I think Byron Blake, as great as he is, felt a little short. Listen, bro, he kills it. We human. You guys can't come down on him because he misinterpreted something. He's not a lawyer, but he's damn close to it in understanding. So we don't tear down our people, especially when they're great. We build them up. Constructive criticism. You don't attack to tear down. You address each one, teach one. Let's go.
Specifically, and this has been a topic for quite some time. Wack has always been saying, I'm not in the paperwork, I'm not in the paperwork. And people have been debating over whether or not Wack was actually involved in this investigation in the eventual charging and incarceration of Big U. Now, here we have it. Right here, the government is saying that Big U is charged. These overt acts are not just things that were mentioned in the paperwork for exercise. You know, these are things that Big U is actually charged with, you know. And the reason why I find that funny is because one of the overt acts says that Big U made a statement saying that he was bigger than Nipsey Hussle. And I'm still confused on how that constitutes a federal crime. But like I said, the government is now saying that Big U is charged with assault on Wack 100. He's also charged with making threats to Wack 100. I'm interested to see how this is going to play out because Wack has been trying very hard to keep his name from being attached to this in the witness aspect. But when you look at things like this, the defendant should remain detained for the safety of the community, the victims and witnesses in this case. In defendant's own words, if I would have had a problem with any man, the issue would have been resolved and he wouldn't be here or I wouldn't be here. And for the hope of some semblance of justice for the families of his victims. Indeed, with seemingly just hours of notice of his pending arrest, defendant has already destroyed valuable evidence, attempted to paint a false narrative of his criminality in the public, and publicly condemned his enemies by name. He cannot be allowed to continue on this obstructive path. They would also state that further, the defendant's release would pose a serious risk to individuals whom have assisted the government in this case, as well as witnesses and victims who have so far refused to cooperate or provide statements because of what they know. As defendant made clear in an intercepted call on January 5th, 2023, being a rat means you are done. Indeed, trying to intimidate and dissuade anyone from cooperating with law enforcement or otherwise reporting information about defendant before turning himself in, defendant posted an Instagram video naming his co-defendants and known opponents, instructing the public to not associate with them and claiming if they did, they were not Black.
Most people have no
Damu Kiwe Conversations. Hey, listen, man, y'all go ahead and bang that like button. Let's go.
What they basically doing here is this is two separate instances where the government was arguing that Big U should not be allowed to have bail. He should not be released. And in each one of those instances, they bring up the video that he made before he turned himself in. Now, if you're not familiar with this video, take a look.
So this is gonna probably be my last video. I'm gonna go turn myself in to see what's going on. They talking about I'm a fugitive. So they just raided all my houses. 600 was actually with the police when they raided my house. And he's actually got video and footage of it. So y'all know what y'all dealing with. And I just want to say this to y'all. When they raided my houses and my property, they was asking about Wack. Wack, loose cannon, 600, and this internet stuff. All of y'all filed. all y'all who be sending shit around the internet, all y'all who be promoting and listening to what they're saying, all y'all giving these likes and hidden likes, all y'all supporting this. All y'all guilty of this shit. If you had something against a black man, you should handle it with a black man in the streets. Wack said 100 times he was gonna take my contracts. He working with the FBI.
When you take that video and couple it with the fact that the government is specifically referencing this Instagram live and saying that, you know, this guy is attempting to intimidate witnesses and victims and possibly deter other witnesses and victims, and they cite that he called out known opponents, it's pretty obvious what's going on here. I mean, Big U is saying, hey, y'all bringing up Wack 100 in these uncharged acts and trying to use this stuff against me. And these aren't even crimes. Y'all haven't presented me no evidence of me doing anything to Wack or saying that Wack was inferior or any type of proof that I did this. And the government is responding saying those are not uncharged acts. Those are charged acts, and the proof will be offered at trial. So we can expect to see at some point during Big U's trial, the government put on a presentation of a crime that Big U allegedly did against Wack 100. And I'm assuming that we are going to see Wack 100 testify in some form. And Wack knows that the time is coming, which is why I believe he made this video.
I always like to come to y'all first about anything I'm doing. I got a tough decision to make. Big U, when he turned himself in, made accusations that Wack 100 and 600, he mentioned loose cannon, which he may very well be, but Wack 100 and 600 was working with the feds to take him down. He said this to the world. My legal team, when it comes to my overall businesses and things that I do, they have some say-so in this matter. So I've been fighting them on what I didn't want to do, which is filed anything against Big U for defamation and slander, as I did with World Star and LA Media, and I won that case, and I got paid. So anybody that talks to this man, communicates with this man, I'm trying my best to keep my legal team from doing what they feel they're obligated to do.
To me, this was clearly Wack trying to intimidate people into not running stories about him snitching on Big U or being involved with Big U's case in any kind of way. Basically trying to put the narrative out there that this stuff is false. But as we see here, Big U is saying, hey, these are uncharged acts that y'all trying to put on my indictment. And the government is saying, no, these are not uncharged acts. These are part of the conspiracy and they are charges. So Wack obviously just talking because you're not going to get to sue. You can't sue somebody for telling the truth. You know, he's charged, bro. And it's related to you now. I'm interested to see how you will explain him being charged with a crime related to an offense with you that you claim you did not cooperate in.
Why is you in his paperwork anyway?
No information that he actually talked to you or threatened you or had an encounter with you, that they will be going forward with this. So obviously they got some information.
Man, why are you in Big U paperwork anyway? Y'all ain't got past that. Let's finish this so I can read this paperwork.
Information that this situation actually happened. Could it be?
Now I'm about to expose something nobody ever knew.
Oh, shit.
So here it goes, right?
Ground zero,
I'm here. All of this is a parking lot, right? I'm here. They walk down. They walk right past my car. They didn't even see me. When I seen them get here, I jumped out. Y'all looking for me? Right?
Shit.
They stopped. They back was to me. Y'all, I had everything I had, I could have dealt with everything in front of me. Now, what they didn't know is I'm talking to my team. Big U is here. Now watch this. Look, watch this. Big U is here. I'm here out the car. Third, who was here, and here?
You taking notes?
Hold on. Third, who in that parking lot when I'm confronting these 20 Crips was 20 to 30 feet in every direction and they didn't know it? All my homies was behind them.
That's new information.
Listen.
That's new information, man.
So listen, check this out. So when I'm letting you know, there's no need to beg nothing. What did I tell that fool? My home, they still don't know to this day that all my homies was positioned 11 o'clock, 2 o'clock, 6 o'clock. They didn't even see them. I'm talking to my homies in code, letting them know which way I'm gonna push them. I said, nigga, ain't number 20 of y'all. I'm going to down 3 of y'all. I just told him I'm going to get off in 3s. When, right? At that point, he knows he's getting off in 3s when he go to 2s, he's running out. These dudes right now to this day had no idea that they was ambushed.
Yeah, man. I don't know, man. I really don't know, man. But what I do know is the time is soon approaching for us to see.
So we that's enough. We got one more video. We're gonna get into Imam. See, practical, you can understand in theory how to build a space shuttle to put someone on the moon, right? How to build the rocket scientists. But until you actually build it, you haven't stumbled across the pain, right? You haven't stumbled across complications that come with that. You know what I'm saying? You don't know the exact diameters necessary until you've done it. And that's what I told Byron Blake before when he jumped out there talking about Sue Surf was the reason Big U was in jail. I agree to disagree with him on that. You know what I'm saying? On Valentine's Day, he kept texting me, arguing about it. On Valentine's Day. You know what I'm saying? Hold on. This is the beautiful Maria. We're going to pause this. Hold on. Listen, man, I don't care how much I'm supposed to have love for y'all. When Maria called, y'all secondary. You understand what I'm saying? We got that big head baby on the way. You know what I'm saying? New addition to the family. You know what I'm saying? Yeah, she's 6 months right now. 6 months. And I'm loving every minute of it. So I think this is the right one. I'm praying this is the right one. No, this is the government's opposition. So we're gonna stop sharing that. And we're gonna stop sharing that, and we're gonna go to Big U's in order. Big U's motion, and then Big U's motion is 34 pages. So let's get off of defendant's motion to exclude prior act evidence, right? Where y'all at? Can y'all see this? Yeah, y'all can see it. So good. And then I'll do a breakdown. Then I'll get into what's the name. So this will be the content for y'all today. Tomorrow, y'all get the governments and the breakdown. Then I'll break them both down in comparison. The hearing time, April 24th, 2026. So they got a hearing coming up April 24th at 1:30 p.m. And I'm going to try to make sure I get some people to go get the content. You know what I'm saying? So defendant Henley, through his attorneys, Craig Harbaugh and Peter Johnson, Sylvester Robinson by and through his counsel. All right, so that's just the certification. And then here it goes. Introduction, legal standard, requirements of federal rules evidence, 404B. This is what it's all about. What is going to be classified as admissible under the 404B Federal Rules of Evidence. The government must satisfy the strict notice and admissibility requirements. The Rule 403 compels exclusion where the probative value is substantially outweighed by unfair prejudice. 3, the argument the court must exclude several general categories of character evidence that the government may seek to introduce at trial. And then B, the court shall also exclude the 12 categories of evidence, section 1 to 12 below, classified in the government's Rule 404B evidence, right? So the June 15th arrest of defendant Robinson and the ghost gun found in Robinson's vehicle. Exhibit D1 to D3. Recorded conversations to which Mr. Henley allegedly discussed the enterprise's use of rolling 16 and 140, 156. That's exhibit E1 to E7. 6, the Nipsey Hussle management dispute. The alleged diss song that claimed that Nipsey had to be disciplined, and the assertion that the dispute with RW unfolded. Exhibit F1 through F39. 7, evidence that Celebrity Socks received $6,000 in SBA funds despite allegedly having no income. I don't know if Celebrity Socks didn't have no income. I think Big U might have sent me a couple $100 through Celebrity Socks, which was his original right? Intercepted calls. Maybe I'm wrong. Maybe he has multiple companies. Intercepted calls and surveillance concerning alleged efforts by Mr. Henley and defendant Martin to use violence or threats to recover recording equipment belonging to Lil Wayne and NBA to H16. Is that H? Yeah, to H16. So they're talking about Big U alleged efforts and Martin to use violence or threats to recover recorded equipment belonging to Lil Wayne and NBA Youngboy. So he's advocating, it sounds like somebody stole some equipment or something, and he's advocating, man, you ain't finna do our people like that. You know what I'm saying? And they trying to bring that in to prejudice his defense. So the juror be contemplating these facts, sensationalized by these facts, and distracted from what the government haven't produced, right? Putting paint where it ain't. Witnesses to anticipated testimony concerning A, his 2016 or 2017 donation for helmets. B, so witness 2's anticipated testimony concerning A, his for helmets, B, the statement regarding Nipsey Hussle, and C, witness 2 allowing Mr. Henley's artist to record for free because he felt he could not say no. So witness 2, if to take an educated guess, is the rat Molly Moe, Wack 100's bestie, the one he put on the phone with Adam 16. 10, donor ones. Anticipated testimony concerning A, his donation as an alleged donor victim, B, an attempt to clear a gambling debt, and C, the allegation that Mr. Henley recovered fraudulent gambling winnings for NBA players. Exhibit J1. So 11, additional sex-related intercepted communications, including November 28, 2022 and January 19, January 7th and 19th, 2023 calls, and alleged January 7th, 2023 payment discussion, and the February 8th, 2023 massage company with happy endings call. Going to indict this man for this. What happened to the owner of the Patriots, Robert Kraft? Oh, I see what's going on. You know what I'm saying? y'all definitely want the leaders from within our community, those with structures, up out of there. But y'all leave those by providing notice of 12 categories of textbook character evidence to an already bloated 43-count first superseding indictment, the FSI. The government seeks to trigger outrage, facts, confusion, facts, and a series of mini trials that will take weeks to defend, serving only to exhaust, distract, and prejudice the jury. Ain't that what I said? Its notice does not identify a narrow set of genuinely probative non-propensity evidence. Instead, it attempts to convert a sprawling collection of alleged other facts, rumors, public boasts, coded statements, celebrity disputes, sexual commentary, unrelated financial conduct, and supposed flight evidence into admissible proof by repeatedly invoking modus operandi, enterprise evidence, or intrinsic evidence. That is not enough. This court should exclude this prejudicial noise and require the government to try its case on the facts, not on character assassination. Facts. Hey, listen, Big U, I don't agree with. I think they left a lot to be done. I'm not better than them. Don't know the law better than them, but I have studied the facts. Had the time to study the facts closely. And there's a lot of things I haven't seen, but a lot of stuff is found. So legal standard. Requirements of Federal Rules of Evidence 404B. I'm going to read this because just like me, none of you guys are lawyers, so we're laymen. And so I can't assume that y'all understand the law. For y'all to get the proper context, we got to read it. I gotta read it. The government bears the affirmative burden of proving all four elements of the Rule 404B test before any other acts evidence may be admitted. 1, the evidence tends to prove a material point. 2, the other act is not too remote in time. 3, the evidence is sufficient to support a finding that the defendant committed the other act. And 4, the act is similar to the offense charge. They cite U.S. versus Cott, a 9th Circuit case, which governs the Central District of California where Big U is being held and charged. B, the government must satisfy the strict notice and admissibility requirements of Rule 404B. Rule 404B 2020 amendment heightened the government's notice obligations, requiring the prosecutor to articulate in the notice the permitted purpose for which the prosecutor intends to offer the evidence and the reasoning that supports the purpose. Federal Rules of Evidence 404B3B. The government may not simply recite a list of Rule 404B purposes and be done. It must articulate precisely the hypothesis by which one or more consequential facts can be inferred from this evidence. They cite United States versus Marmonesh, another 9th Circuit case out 1982. Likewise, the government may not simply conjure up a proper purpose. It must also establish a chain of inferences, no link of which is based on a propensity inference. They cite U.S. versus Smith, 3rd Circuit, 2013. This logical connection must be supported by some propensity, free chain of reasoning, and they cite U.S. versus Rodriguez, 9th Circuit, 2018, quoting U.S. versus Gomez out the 7th Circuit, 2014. C, the inextricably intertwined doctrine cannot be used to circumvent Rule 44B. So off the top, Big U's attorneys is saying, y'all, the U.S. attorney is trying to say it's inextricably intertwined, this hearsay evidence, these wiretaps evidence is inextricably intertwined doctrine, and they're utilizing that to rush evidence through the doors in mass drones to be able to do, say, prejudice and contaminate the jury pool and the jury's mind with a lot of other distracting stuff that doesn't necessarily pertain to the case. The inextricably intertwined doctrine is a narrow exception that cannot be used to bypass the protections of Rule 404B. Many circuit courts reject the doctrine entirely because it has outlived its usefulness and become overused, vague, and quite unhelpful, citing U.S. versus Gorman at 7th Circuit, 2010. As the 3rd Circuit, so 7th Circuit, 3rd Circuit, has noted, the inextricably intertwined test is vague, overbroad, and prone to abuse. And we cannot ignore the danger it poses to the vitality of Rule 404B. So you have some appellate courts already making mention of how it's broad. You know what I'm saying? It's vague. It's overbroad and it's vague, right? It's prone to abuse because it's going to allow evidence that prejudices the defendant and now his constitutional right to a fair trial on the charges that he's set with aren't the issue. He's being denied that. He'll be fighting multiple charges that aren't even charged. So the 9th Circuit recognizes only 2 narrow categories of evidence that may be deemed inextricably intertwined. When the act constitutes a part of the transaction that serves as the basis for the criminal charge, or is necessary to permit the prosecutor to offer a coherent and comprehensible story regarding the commission of the crime. U.S. versus Loftus, 9th Circuit, 2016, and U.S. versus Cervantes, right? Another 2016 case. 1, conspiracy cases do not exempt every uncharged act from Rule 404B. The government may rely on the proposition that in conspiracy cases, it may prove the full scope of the conspiracy. United States versus Risk, 9th Circuit, 2011, and U.S. versus Montgomery, 2004, the 9th Circuit. That proposition, however, does not mean every uncharged act connected in some way to an alleged conspiracy or enterprise is automatically inextricably intertwined. The 9th Circuit makes clear that the doctrine remains narrow. Visaria Martinez, critically, even in the RICO context, the government must make an affirmative. Now you notice they differentiate conspiracy and RICO because RICO gives the U.S. attorney superpowers. These are the type of powers that you're given to overzealous prosecutors. Critically, even in the RICO context, the government must make an affirmative showing how proof of each incident it seeks to admit constitutes proof of the scope of a charged conspiracy to avoid a Rule 404B analysis. Again, they cite Cervantes. Where the government seeks to introduce uncharged acts that are not alleged in the indictment as predicate racketeering acts or acts in furtherance of the conspiracy and fails to provide Rule 404B notice, the court should exclude the evidence. Bass, Supra at 11. Where uncharged acts are sufficiently disjointed from the charged pattern of racketeering activity, they cannot be deemed inextricably intertwined and must be subjected to the strictures of Rule 404B, citing Cervantes. Furthermore, the use of uncharged acts to prove a RICO conspiracy raises acute jury instructions and jury unanimity issues, as the jury may improperly rely on non-predicate overt acts to reach a verdict. ID at 1233 discussing U.S. versus Frege. D, Rule 403 compels exclusion where the probative value is substantially outweighed by unfair prejudice. There has to be a scale of justice, right? Even where 404B evidence falls within a permitted purpose, it should be excluded under Rule 403, where if the court finds that its probative value is substantially outweighed by a danger of unfair prejudice. U.S. versus Preston, 9th Circuit, 2017. Character evidence is said to weigh too much with the jury and to so over persuade them as to prejudge one with a bad general record and deny him a fair opportunity to defend against a particular charge, meaning the charge that he was charged with at this time. They were convicted him because of his past or his reputation, his character, right? The 9th Circuit has established that a court does not properly exercise its balancing discretion under Rule 403, where it fails to place on the scales and personally examine and evaluate all that it must weigh. U.S. versus Curtin, 9th Circuit, 2007. The court is required to have read every word of the evidence, because one cannot evaluate a Rule 403 context what one has not seen or read. This every word requirement is applied consistently across all categories of evidence. U.S. versus Lay, so that's 9th Circuit, which says, assuming without deciding that the district court abuses discretion by failing to preview all of the prescription data before granting the government's motion in limine. U.S. versus Waters, another 9th Circuit, determining that it is the court's responsibility to read every page of the articles. 9th Circuit, 2015, reversing where the court failed to review prior interviews. So they're basically showing the judge, look, you have to review this and read every word and every line before you make a decision on what's going to be admissible. And they need to be seen and viewed in their own context individually, because some you might find are pertinent and material, others you might find otherwise. I'm getting a call from the beautiful Maria. Hold on. Hey, well, you know, that's what them hormones do when they pregnant. But y'all got to bear with us, man. We gonna make all this work. So third, the argument, right? The court must exclude several general categories of character evidence that the government may seek to introduce at trial. The first superseding indictment, FSI, while expansive in its RICO allegations, threatens to devolve into a circus of other acts that are not predicate acts of the RICO. Oh, I'm on the wrong page, bro. My bad, man. Let me go ahead. Let me go ahead. No, I'm on the right page, right? So I'm apologies, man. You know what I'm saying? Apologies, man. All right, charged in any substantial count and serve only to prejudice the jury. Pursuant to federal rules of evidence 404B and 403, Mr. Henley moves to exclude several categories of highly prejudicial evidence, including 1. Sensationalized references to celebrities and deceased public figures. Smart. 2. Inflammatory social media posts and media commentary from podcasts or documentaries that reflect Mr. Henley's public persona rather than the specific criminal acts charged. Smart. Irrelevant evidence of uncharged financial transactions, gambling activities, and unrelated tax issues. Smart. And 4, references to the Rolling 60s neighborhood Crips, where such evidence is purely prejudicial and not strictly necessary to prove an element of the alleged RICO enterprise. Smart. The court should also exclude the 12 categories of evidence, sections 1 to 12 below, identified in the government's Rule 404B notice, as detailed in the sections that follow. Each of the 12 categories fails the Ninth Circuit's 4-part test for admissibility under Rule 404B. 1, it does not prove a material element of the offense. 2, the prior act is too remote in time. 3, the evidence is insufficient to support a finding that the defendant committed the act. And 4, the act is not sufficiently similar to the charged offense. Even if the evidence met this criteria, its probative value is substantially outweighed by the danger of unfair prejudice, confusing the issues, and misleading the jury under Rule 403. 1, check-in evidence, Exhibit A1 through A8. First, the proffered material is quintessential propensity evidence dressed as branding. The government seeks to transform a phrase, persona, and media presence into proof that Mr. Henley acted in conformity with an alleged extortionate practice. Rule 404B squarely prohibits this reasoning. See Federal Rules of Evidence 404B1. Second, the government's notice is facially deficient. It fails to identify with any specificity the particular clips, recordings, images, or witnesses it intends to introduce. The notice vaguely states that it will offer clips of defendant Henley discussing the check-in. What can happen if you do not check in, including to film crews, what he has done to those who do not check in, and the existence and theme song of the Checking In podcast, Exhibit N. Snoop Dogg made that song. So are you indicting and saying that Snoop Dogg, a veteran hip hop artist of almost over 30 years, is criminally a conspirator because he made a song about checking in and the dangers to those in the industry who just come around willy-nilly? It's a warning. A warning not of Big U, but of those wolves in LA. It's nasty work, bro. This sweeping description is inadequate to permit either the defense or the court to conduct the required Rule 404B and Rule 403 analysis. Exclusion is warranted on this basis alone. Third, the limited material the defense can identify, particularly a video apparently referencing film crews, is remote in time, lacks foundation, and does not establish any extortionate conduct. Exhibit A7. Undersigned counsel is informed and believes that this content dates to approximately 2017, outside the time frame of the overt acts alleged in the first superseding indictment. Such unsubstantiated temporarily remote material cannot satisfy Rule 404B's threshold requirements and carries a substantial risk of misleading the jury. I agree. But I'm telling y'all, those superpowers from the RICO, it'd be so hard. It'd be such a fix. But this is definitely a great move by Big U's attorneys, preserving these issues for a possible appeal, right? In case they do too much, and that gives them opportunity to get back on the appeal. But it also forces the judge, if he is just, to weigh each evidence on its own before making it admissible, going through each one, which is going to take time. And it might also be a tactic to get what the attorneys have been wanting. Big U haven't want to waive no more time, but to force the judge to go through all of this and have to give Big U attorneys more time to prepare for trial, right? Okay. Fourth, the government's theory improperly attempts to retrofit a broad check-in narrative onto charges that are pleaded in materially different terms. Although the indictment references checking in as a purported mechanism, none of the 184 overt acts alleges a check-in. See FSI overt acts 1 through 184. This is a strong point, bro. Not one of 184 overt acts alleges a check-in. But they want to introduce this prejudicial evidence because it's intrinsically entwined to the RICO charge. His modus operandi. If Big U judge finds that it is, that could be prejudicial because it's so far outside the spectrum of the overt acts and the substantial crime. In fact, Big U has never been charged with extortion on a check-in. So, instead, the government's own pleading uses terms such as tax, rent, donation, and payment. The proffered check-in evidence is thus untethered to the specific conduct charged and risk inviting a verdict based on generalized reputation or fear rather than proof of the alleged predicate racketeering acts. Fifth, the proposed introduction of a podcast theme song associated with a well-known artist raises distinct constitutional and evidentiary concerns. Courts have recognized the heightened risk of unfair prejudice when the government seeks to use expressive or artistic content as substantive evidence of criminal conduct. U.S. versus Williams, right? Finally, any marginal probative value of this category of evidence is substantially outweighed by the danger of unfair prejudice, confusion of the issues, and misleading the jury. Federal Rules of Evidence 403, permitting the government to present generalized rhetoric, media branding, and artistic expression as proof of a pattern of racketeering would shift the trial from adjudicating specific alleged acts to evaluating a persona. Accordingly, all check-in evidence should be excluded. 2, Defendant Williams' public statement. Loose the liability cannon. The fake loose cannon. Terrain, sweetie! How did all of y'all try to claim that he wasn't snitching or lie snitching when he did that interview on No Jumper. And Wack 100 is the one that orchestrated Loose Cannon to do this third-party cooperation, open source intel on No Jumper. Wack 100 is Big Meats. I think I'm Big Meats. Big Meats. Tekashi 6ix9ine. Gucci Mane. All these niggas Pizzor. Swizzine. So, first statements by Williams are not admissible against Mr. Henley simply because the government says they illuminate enterprise structure. If Williams does not testify, admissions of these statements raises serious hearsay, confrontation clause, and Bruton concerns. Now, this is a major issue, right? So I'm gonna do a video on where the six, matter of fact, I'm gonna try to see if I could do it right now, right? Let me see how long. No, I'll do that on another video, specifically where the confrontation clause came from and why it's so important, right? If Williams did not testify, admissions of these statements raises serious hearsay, confrontation clause, because you have to have a right to confront your witnesses. Well, Tremaine is a defendant, and his attorneys might not want him as a defendant to take the stand because it opens him up to all kind of other liability. So strategically, he don't want to take the stand, but Big U has a right to confront all witnesses and statements used and made against them, right? So this is a powerful argument. Salute to Big U's attorneys on this one. Second, if the government invokes Rule 801 D2E, it must first establish with independent evidence that the statements were made during and in furtherance of the charged conspiracy. Third, even apart from hearsay, the label enforcer is unfairly prejudicial and conclusory. Right? I'm big useless enforcer. Who believes that? You know what? I think the jurors should hear that shit so they can know that this nigga full of shit. Fourth, the No Jumper incident risks devolving into a mini trial within a trial concerning an uncharged robbery with powerful spillover prejudice. The court should exclude the category in its entirety. The catch-all fear and control over community and victims category, including reliance on overt acts 107, 110, 111, 145 through 170 generally, exhibits C1 through C28. This omnibus, I guess I pronounced that right, omnibus category is too vague to permit meaningful notice and too broad to allow fair litigation. The government cannot admit a sweeping block of alleged overt acts, generally, as proof of fear, power, and control without identifying the specific evidence, witness, exhibit, and non-propensity purpose for each item. Rule 404B requires a disciplined, item-by-item, propensity-free chain of reasoning, not a thematic narrative untethered to particularized proof. Oh, they shot this thing. They calling it AUSA out on they bullshit. They on bullshit, bro. This is how niggas get railroaded, bro. This the type of shit that the judge can stick his hand too heavily on the scales of justice and you get railroaded. You know what I'm saying? Man, prayers for Big U, prayers for Big U family. Nonetheless, each of the overt acts cited below and the associated evidence should be excluded from evidence pursuant to Rules 401, 403, and 404B. Overt Act number 106, Exhibit C1 to C2. On February 14, 2023, on an intercepted call as part of the extortion scheme, Defendant Robinson told Defendant Henley that Defendant Robinson told Jew Boy that he owed the Big U Enterprise money, that they would allow a payment plan, but if he did not pay, they were going to shut this motherfucker down. Defense's response. First, nothing in the call indicates that the contents of the
Mike
call
Jones TV
relates
salute.
to extortion, as opposed to a business dispute. Second, the statement, shut this motherfucker down, is ambiguous and is not a threat of violence. That's a hell of an argument. I'ma shut this motherfucker down could be all business. Nigga ain't no more weed dispensary or whatever the business he had with the alleged Jew boy, right? Third, evidence related to Jew boy is not a predicate act, and the government has given no indication that it will call Jew boy as a witness to prove a predicate act or to assert that he was in fact extorted. Oh, you think that the government ain't gonna bring this small hat to come corroborate that? The small hat was already an informant. In fact, the small hat was sentenced to jail and has been out 7 years without ever turning and doing a day in jail. And you mean to tell me that Big U attorneys don't believe that this alleged Jew boy is going to be a witness? I'm not sure about that, but I'll make sure that that research that I got on looking for this alleged Jew boy, that make sure that I get that to Big U's attorney, that information, because that might be an incentive for him to lie, right? Because he's trying to work so he don't have to do a day in jail, the prison sentence that he was sentenced to, right? And so fourth, introduction, I'm starting to see a trend, right? So he's ducking jail time. Ain't no telling what Marley Marl's ducking. You got Dale Morrison, long tail Dale the Rat. He's ducking jail time and another indictment and sentencing in Ohio that he got caught up on. And they're gonna they recruited these guys who were compromised with things that had nothing to do with Big U. And we'll give you this if you say this. We'll take time off your sentence if you testify against Big U. Nasty work, bro. So fourth, introduction of this extraneous and extraneous and out of context call will be a confusing waste of time and result in a mini trial about an act that does not relate to any extortion counts in the FSI. Overt Act number 110, Exhibit C3 to C6. On April 11, 2023, on an intercepted call, Defendant Henley and Blanton discussed an individual whom the Big U Enterprise was planning to rob in the near future. Defense response. First, the call and the overt act provide no victim, no location, and no evidence any robbery was ever planned, attempted, or completed. This is vague, conclusory allegation with no corroborated evidence. See, corroboration, Wack 100 corroborating. Yeah, you know why he kept the gave back the 40, because he was gonna keep 20, right? Those are corroborating evidence. In these type of cases, that's what it requires to get indicted, to get convicted. to even have evidence admissible into court. Wack understands that. And that's why he was on there corroborating modus operandi against Big U. Oh, this is how you do it, right? Second, the alleged plan to rob in the near future does not connect in any way to the Hobbs Act robbery alleged in the FSI. In short, the government cannot sustain a RICO overt act on a conversation with no identified victim, no follow-through, and no specifics. Therefore, the court should exclude the call. Agreed. Overt Act number 111, Exhibit C7 to C11. On April 17th, 2023, on an intercepted call as part of the extortion scheme, defendant Henley, I told y'all, when Maria called, y'all got to get put on pause. Pause. So, Overt Act number 111, Exhibit C7 to C11. On April 17th, 2023, on an intercepted call as part of the extortion scheme, defendant Henley directed an individual to deliver a message to another marijuana dispensary owner that defendant Henley said, fuck him, and that he fucked with the wrong guy. What does that got to do? Defense response. First, the government does not explain how the events described in the call are sufficiently similar to the charged conduct necessary to prove a genuinely disputed issue or more probative than prejudicial. Second, the call contains no threat of physical violence, no demand for money, and no identifiable victim. Third, the government is attempting to criminalize profane speech. The statements fuck him and he fucked with the wrong guy is crude language, not a criminal threat. Fourth, without evidence of a prior relationship, a demand, identification of the alleged marijuana dispensary owner, or a follow-up act, this does not constitute extortion or a pattern of racketeering activity. Fifth, introduction of this call is not necessary for a coherent story. Part of the same transaction of extortion offense alleged in the first superseding indictment. Overt Act number 145. In November 2022, defendant Henley arranged for a co-conspirator to collect an illegal debt from a current NBA All-Star player who purportedly owed $3 million to a Big U enterprise associate. Defense response. By mentioning NBA All-Star players gambling, illegal debts, and millions of dollars, the government is attempting to turn the trial into a confusing circus where distractions lead to conviction. Man, that's so fact, especially because the NBA got that other investigation going on right now, right? This is unacceptable, right? This invites propensity reasoning and celebrity tainted prejudice. It has nothing whatsoever to do with the counts charged. It is not necessary for a coherent story and is not part of the same transaction of extortion or robbery offenses alleged in the superseding indictment. Further, debt collection, even aggressive debt collection, is not per se extortion. Without evidence of threats, force of fear, this allegation is legally insufficient. Unless the government can establish a direct, concrete, non-propensity connection to a charged count, the court should exclude the evidence under Rules 401, 403, and 404B. That's a good question to ask ChatGPT, right? is debt collection or even aggressive debt collection. Bear with me because I want to get to this. Per se, extortion. So we finna find out this right now. The short answer, no. Debt collection itself, even aggressive collection, is not extortion. But it can become extortion if certain lines are crossed. So this in itself does not mean it was extortion. The government doesn't want to prove or show any evidence that this was per se extortion until trial, to after they prejudice the jurors. This is nasty work. Overt Act number 146, exhibits C12 through C15. In October 2022, defendant Henley took a portion of the debt that current NBA All-Star player owed as a fee for collecting the illegal debt. Defense response, as stated above, introduction of this call and evidence is an unnecessary and prejudicial distraction from the core of the charges in this case. Further, accepting a fee for facilitating a financial transaction is not a crime. Introduction of this evidence by the government will result in a distracting side trial regarding whether the underlying debt collection itself was criminal. For that reason, the court should exclude this call and any evidence related to this transaction from the government's trial presentation. Whoo! Big U lawyer, bing, 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 bing. They're really making the judge think about each one of these BS elements that they're trying to introduce broadly under, because it's the RICO superpowers, and totally violate Big U's constitutionally guaranteed rights to a fair trial. How is it fair if you're trying to convict me on alleged crimes that weren't crimes, that were never proven to be crimes? But you want that introduced to the jury without sanitization. Nasty work, bro. On November 7th, 2022, on an intercepted call after an extortion victim stated that defendant Henley had not fully paid the extortion victim for work on defendant Henley's vehicle. Defendant Henley directed defendant Martin to call the extortion victim right now and stated that he would go out there and kill that nigga. Defendant Martin then connected defendant Henley with the extortion victim and participated in the extortionate call. Defense response. At best, this is a civil dispute over payment for work done on a vehicle. The hyperbolic language, kill that nigga, is common vernacular in this cultural context and does not constitute a threat. The government must prove the statement was intended and understood as a genuine threat of imminent violence, not frustrating venting. Again, these inflammatory and prejudicial calls offer speculative probative values and will result in a waste of time in defending against unrelated acts that are not connected to the charged offense. Baby Skylar is killing me. Let me pause this. So, at best, this civil dispute over payment for work done on a vehicle, the hyperbolic language, kill that nigga, is common vernacular in this cultural context and does not constitute a true threat. See Virginia versus Black, 538 U.S. 343. This Supreme Court, they cited the Supreme Court 2003. The government must prove the statement was intended and understood as a genuine threat of imminent violence, not frustrated vengeance. Again, these inflammatory and prejudicial calls offer speculative probative value and will result in a waste of time in defending against unrelated facts that are not connected to the charged offense. Overt Act number 148, Exhibit C28 through C29. On November 14, 2022, on an intercepted call, defendant Henley described to a former NFL player that defendant Henley would beat the shit out of the producer who owned of the studio in Las Vegas because he started shit between defendant Henley and Wack 100. When we go live, I'm gonna make sure I bring the video, which is going to tell you what he said. The Wiretap, which also says that Big U told Molly Mall to cut Wack 100 off because he's a federal informant. Molly Mall tried to start some shit and ran back and told Wack 100, man, he on to you, man. He told me you was an informant. Well, Molly Mall is also an informant, a legend. You know what I'm saying? So, yeah, man. Now, here it goes. Now, let's hear what the defense response is to that. Again, this is an attempt to distract the jury with a mention of famous NFL players. Further, this is a private conversation expressing personal frustration, not a threat communicated to the producer, not a demand for money, and not an act in furtherance of any charged scheme. There is no evidence that the producer was ever contacted, threatened, or harmed. As such, this is just another unnecessary distraction. Overt Act number 149, Exhibit C30 to C31. On November 22nd, 2022, on an intercepted call, defendant Henley told an incarcerated individual that anyone coming at him better come correct because defendant Henley always has two blowers, i.e. firearms on him. He could be bluffing. The man wears sweats every day. Where he got the two blowers? I mean, come on, man. But anyway, so he got two blowers on him in sweats. Ain't that a bitch? But anyway, defense response. At best, the statement was made to an incarcerated person in a private conversation, not to any victim, not in furtherance of any robbery or extortion. It is street-level bravado, not a criminal act. The government has not identified any victim who heard this statement or was placed in fear by it. Mere possession of firearms, if true, is a separate matter, not charged any count in the indictment. As such, this is just another distraction from the evidence in the case. Overt Act number 150, Exhibit C30 to C31. On November 22nd, 2022, on an intercepted call, defendant Henley told an incarcerated individual that defendant Henley was going to charge someone in federal prison $6,000 to have a phone smuggled to him. Defense response. This allegation is entirely unrelated to the charge RICO enterprises alleged purposes of extortion, robbery, murder, or fraud. There is no identified victim and no evidence this ever occurred. The government is padding the overt act list with uncharged, unsubstantiated conduct to inflate the appearance of a criminal enterprise. As such, this cause should be excluded. Good argument. Overt Act number 151, Exhibit C35. On November 23rd, 2022, on an intercepted call, defendant Henley said that he can pay 3 people $50 each to beat someone up. Defense response. This government does not identify who Henley was speaking to, who the target was, or whether any assault ever occurred. A hypothetical statement about what one can do is not an overt act in furtherance of a conspiracy. This is speculation, not evidence of a completed or attempted criminal act. Great argument. Overt act number 152, Exhibit C34 to C35. On November 23rd, 2022, on an intercepted call, defendant Henley described paying people to mess up a store that was refusing to provide defendant Henley a discount. Defense response. No victim is identified, no store is named, no assault is alleged to have occurred, and no payment is documented. This is an unverified, unsubstantiated statement with no corroboration. No corroboration. This one gotta be out of here. This is a great argument. The reason they always, for conspiracy RICOs, need corroborating evidence is to get it admissible into the court. And whether it's the superpowers of a RICO, whether it's a conspiracy, or whether it's a continual criminal enterprise, CCE, you cannot erase his constitutional right to a fair trial. This speculative evidence that has not been corroborated with 20,000 wiretaps, 4-year investigation, should not be admitted before the jurors. Overt Act number 153, Exhibit C36 to C37. On December 27, 2022, on an intercepted call, defendant Henley told a Big U Enterprise associate that they need to hang OG Crip. They need to hang OG Crip, cuz. Defense response. The government has not identified OG Crip, cuz, has not alleged an assault occurred, and has not established that his statement was understood as a directive to commit violence. Overt Act number 154, Exhibit C38 to C39. On December 27, 2022, on an intercepted call, defendant Henley told another Big U Enterprise associate that OG Crip cuz needed to be disciplined thoroughly for a violation of cripping. Defense response. The government has not alleged that any physical act of discipline occurred, identified the victim, or established that this statement resulted in any harm. The government is attempting to criminalize speech about internal community norms without proving any criminal act followed. That's a fact. Overt Act number 155, Exhibit C40 to C41. On December 30th, 2022, on an intercepted call, defendant Henley said that when defendant Henley catches Wack 100, I'ma break his jaw. The defense responds. This is a private statement of frustration, not a threat communicated to Wack 100. There is no evidence Wack 100 ever heard this statement, was placed in fear, or was harmed. The government has not charged any assault on Wack 100. So that's a lie. So, well, not a lie. That's a misnomer. If you read the paperwork on wiretaps, Dale Morrison told Wack 100 and passed that message to him. So that's why he became a victim. And then Marley Marl, once Big U told Marley Marl, leave Wack 100 alone, he's a federal informant. Wack 100 then got the word because Marley Marl ran to him and told him that. So yeah, they're misinterpreting the chain of the word of mouth and how it was spreading. Wack 100 was well aware that Big U wanted that fade. On top of that, when did FBI begin investigating Big U for RICO? So this was December 2022. Big U was already on Wack 100 helmet at that time, cut him off and wasn't fucking with him. The murder of RW was January 2021. So you're basically saying a year and a half. So we don't know how long. Okay, I was just checking that out. So there was no evidence Wack 100 ever heard this statement, was placed in fear, or was harmed. The government has not charged any assault on Wack 100. Overt Act number 156, Exhibit C42 to C43. On December 31st, 2022, on an intercepted call, Defendant Henley said that Defendant Henley was bigger than the deceased rapper Nipsey Hussle, that Defendant Henley disciplined Nipsey Hussle, and that Defendant Henley was bigger than any other Rolling 60. Defense response: this is a statement of personal status and reputation, not a criminal act. Nipsey Hussle is deceased and cannot be a victim. The government is using this statement to inflame the jury with the name of a beloved public figure. Facts. The statement does not allege any specific criminal act and is inadmissible character evidence under Federal Rules of Evidence 404B without a proper limiting purpose. Overt Act number 157, Exhibit C4 to C45. On December 31st, 2022, on an intercepted call, Defendant Henley said that if anyone has an issue with Defendant Henley, they will no longer be alive. Defense response: this is a private statement made in a private conversation, not communicated to any identified victim. The government has not identified who Henley was speaking to, who the statement was directed at, or whether anyone was placed in fear. Hyperbolic or hyperbolic statements of self-defense or dominance made in private do not constitute criminal threats. Yeah, that's a fact, bro. That you see what kind of prejudicial evidence they're trying to introduce to the trial jury so they could get him convicted by prejudicial evidence and not the actual crime. If they had case was so strong, why would they need to try to prejudice them with these other things, right? Overt Act number 158, Exhibit C46 to C47. On January 1st, 2023, on an intercepted call, Defendant Henley said that he was not beefing with Nipsey Hussle, because if anyone beefs with Defendant Henley, I'ma kill him, period. I am going to murder him. So, mind you, Nipsey Hussle's already dead. So he's saying, I wasn't beefing with him. If it was beef, I'm going to kill somebody because I'm fearing for my life. Anyway, defense response. This statement was allegedly made on January 1st, 2023, nearly 2 years after Nipsey Hussle's death in 2019. At best, Mr. Henley is speaking in the past tense about a deceased individual. The statement is not directed at any living victim, was not communicated to any victim, and cannot constitute a true threat. The government is using this statement to inflame the jury and to bootstrap the RW murder allegation through innuendo. That's a fact. Overt Act number 159. Exhibit C48 to C49. On January 2nd, 2023, on an intercepted call, defendant Henley told Big U Enterprise associate DS that to manipulate the press for DS's lawsuit against law enforcement, DS should show both positive and negative parts of his life, wear glasses, and say that he was working with developing options, even though he was not. Defense response. This is an attempt to introduce the jury to an unrelated lawsuit, not obstruction of justice, not witness tampering, and not a RICO predicate act. Advising someone on how to present themselves favorably in a civil lawsuit is not a crime. The government has not charged Henley with obstruction in connection with DS's lawsuit. Overt act, number 160, Exhibit C50 and C51. On January 2nd, 2023, on an intercepted call, defendant Henley told Big U Enterprise associate DS that defendant Henley needed to at least break the producer's jaw. Now, I could see Big U clowning. Man, I gotta at least break the nigga jaw, man. Come on, M. But he's clowning, bro. I can't let him get away with that, and we laugh about it. But he's not even tripping off this dude, right? Defense response. This statement was allegedly made in a private conversation with DS, not communicated to the producer. There is no evidence the producer was ever contacted, threatened, or harmed in connection with this statement. The government has not charged any assault on the producer. At best, this is frustrating venting and not a criminal act. Overt act number 161, Exhibit C52, C53. On January 3rd, 2023, on an intercepted call, defendant Henley described to an incarcerated individual tooling up with firearms to travel to a Crips neighborhood because we are the most arrogant, bougie, self-righteous motherfuckers on planet Earth, right? Defense response. No victim is identified, no assault is alleged, and no specific criminal act is described. At best, the statement is a boastful expression, not an overt act in furtherance of any charged scheme. The government has not alleged and cannot establish that Mr. Henley traveled to any neighborhood, possessed any firearm, or committed any act of violence in connection with this statement, because if he did, he would be charged with it. So this is not relevant conduct. Overt act number 162, Exhibit C54 to C55. On January 3rd, 2023, on an intercepted call, defendant Henley told an incarcerated individual that defendant Henley was going to purchase 6 miniature phones to send to the incarcerated individual so that he could sell them in prison for $1,000 each. I wonder who that was. Defense response. This allegation is entirely unrelated to the charge RICO, predicates of extortion, robbery, murder, or fraud. There is no evidence this ever occurred, no identified prison, and no identified buyer. The government is again padding the overt act list with uncharged, unsubstantiated conduct that has no nexus to the charged enterprise's alleged criminal purposes. Overt act number 163, Exhibit C56 to C57. On January 5th, 2023, on an intercepted call, defendant Henley said that another individual was done for being a rat. Defense response. The government has not identified who Mr. Henley was speaking about or what action, if any, followed. Expressing disapproval of an informant in a private conversation is not obstruction of justice, witness tampering, or a RICO predicate act. The government must prove a specific criminal act, not a cultural attitude. Overt Act number 164, Exhibit C58 to C59. On January 12, 2023, on an intercepted call, defendant Henley said he wanted to beat the shit out of Wack 100. Defense response: the government has not identified what action, if any, followed, because none did. Expressing disapproval of an informant in a private conversation is not obstruction of justice, witness tampering, or RICO predicate act. The defendant must prove a specific criminal act, not a cultural attitude. So we're talking about a private conversation is not tampering with a witness, because Big U wants to beat the shit out of Wack 100. So if any action followed, no action followed. Big U never got to fade up or get in the gloves with Wack 100 and beat the shit out of him. You can set up a fight. I'm quite sure y'all seen Blueface just have a fight that was set up by Wack 100 in the gloves. We also got the pay-per-view it, which legalized having a fight and beating the shit out of someone, right? However he had to do it, he wanted that fame. But the government, but Big U's lawyers is saying, expressing disapproval of an informant in private conversations is not obstruction of justice. They talking about Wack 100. Wack 100 CS2 back. In the same line, Big U's attorneys just let the rat out of the bag. They got the rat in the rat trap by identifying, talking about an informant. Well, who are they talking about? Defendant Henley said he wanted to beat the shit out of Wack 100. So expressing disapproval of an informant in private conversation is not obstruction of justice. It is not witness tampering, or it is not a RICO predicate act. The government must prove a specific criminal act, not a cultural attitude. I don't fuck with rats. Y'all can't charge me or introduce this statement that I said, fuck that nigga. I want to beat Charleston White ass. Didn't say I'm going to beat his ass. I want the fade. We could get in the ring with the gloves on, or UFC match, whichever state would make it legally lawful. Why is this information about this alleged informant? Well, I'm going to say he didn't say alleged informant. He said an informant. Why is me speaking in private about this informant relevant to this case? See, my boy Byron Blake was off, but like I said, that doesn't exclude Wack 100 and his fingerprints all over this case. It doesn't exclude Big U's lawyer referring to Big U talking about an informant as it pertains directly to Wack, a statement about Wack 100 not being obstruction of justice or witness tampering or a RICO predicate act. This is nasty work. Overt act. Matter of fact, clip that. You know what I'm saying? We finna read that one more time. Clip that. Right? Overt act number 164. Let's blow this up big. On January 12, 2023, on an intercepted call, defendant Henley said he wanted to beat the shit out of Wack 100. Defense response: The government has not identified what action, if any, followed because none did. Expressing disapproval of an informant in a private conversation is not obstruction of justice, witness tampering, or a RICO predicate act. The government must prove a specific criminal act, not a cultural attitude. So we gonna end that part right there because it's time to cook. I hope everybody shakes the thing. Somebody going over to the Active Chuck channel. Tell them to come on over here because we finna cook. You know what I'm saying? So I want y'all to see this first, right? First, I want y'all to see this, right? We can get back to that right now. Let's go over here. Okay. It's time to cook. And then we got a couple things from the lawyer. She made some videos or whatever pertaining to the Big U case. So look, this Chat GPT. You're zeroing in on the key legal chess move, and this is where the defense is being strategic. What the lawyer is actually doing, the defense is tying two separate wiretaps together. Wiretap number one, Big U allegedly says he wants to beat up Wack 100. Wiretap two, Big U allegedly tells someone to stop dealing with Wack 100 because he's a federal informant. So who is the informant Big U lawyer is referring to? They are clearly referring to Wack 100. This is Chat GPT. It don't take a whole bunch of sense. You ain't got it. Ain't rocket science. Big U lawyer is clearly referring to Wack 100 as the informant. The defense is trying to reframe the meaning of the first wiretap. Instead of violent intent criminal act, they want it to be seen as personal frustration and distrust of someone believed to be an informant. The legal play being made, the lawyer is essentially arguing this isn't a criminal conspiracy or RICO predicate. This is a private conversation expressing dislike for someone who believed to be cooperating. That's important because RICO requires actual criminal acts or enterprise activity. Obstruction, witness tampering requires intent to interfere with a case. Simply calling someone an informant or saying you don't rock with them is not illegal by itself. The implication, if the judge agrees the wiretap about beating him up could be seen as non-actionable talk, cultural expression, exaggeration, not tied to an actual criminal step. If the judge disagrees, the prosecution will argue in its intent. So, and yes, the informant, this wasn't about committing a crime. It was about reacting to someone they believe was an informant. The informant, and yes, the informant they're referring to is Wack 100 based on two wiretap connects. This is nasty work, bro. This is nasty work. And I hope everybody share this. Somebody going over to Active Chucks, tell them that we're over here on Lamonte Sims. They could catch the live over here. It's already late, but we gonna finish this up. So let me get to some of this real quick because let me see where it's at. I thought it was over here. Oh yeah, it is. Hold on, here it go right here. So we gonna go to this. I seen this, and it was pertaining to Big U's, and I'm no lawyer, but she is. Hold on, y'all. Make sure y'all go over there.
RICO case, think of an overt act as proof that it wasn't just talk. It's something real that actually happened to push the situation forward.
Oh, my bad.
Forward. It can be small. It can be a meeting. It can be sending money. It doesn't have to be dramatic. And an overt act can be shown by a phone call alone. Nobody on that phone call has to take the stand for the jury to hear that. If a defendant is on a phone call saying something like, I beat up Joe or I disciplined John, you can play that because it's the defendant's own statement that comes in as a party admission. They don't need the defendant to testify, and they don't need John or Joe to be there to prove the statement was made. Now, whether John or Joe have to come in to testify depends on what the prosecution is trying to prove. If they're just using the call to show the defendant's mindset or intent or steps that he was taking towards something, then no, John or Joe do not have to come in and testify at all. In those examples, the statement itself does the work. But if the prosecution is trying to prove something further beyond the statement, like an assault that occurred after or injury or specific facts about what happened to John or Joe after, that's when John or Joe could be important as witnesses that need to come testify. I'm attorney Jasmine and I practice in LA. And here's what I want you to do today. Put yourself in these shoes for just a minute. You're on the phone, talking how people talk. Maybe you're venting, maybe you're joking, maybe you're hyping yourself up, and maybe you're not. But let's say for this exercise, you're saying things you would never actually do. You would never actually follow through on. You're just talking. Now imagine yourself sitting in a courtroom in a RICO case, and your call or calls from years ago are being played for a jury, and the jury is being told, this is what you intended. This is why you said that. This is what you meant. And no one from that call has to show up. Not the person you were talking to, not the person you were talking about. The jury will hear your voice, your words, and since it's more than likely a snippet of that phone call and many other phone calls, then it is clearly, in many cases, stripped of actual context, and it's being played in a quiet courtroom, and it's not in the same kind of surroundings or environment that you actually made the call in and that you actually have the conversation in. And now those words are being used to prove that you took a real step towards something. So what might have felt like nothing at the time, just talk, just energy, just a moment, suddenly carries weight. And the question becomes not just what you did, but how those words sound when someone else is deciding what they think you meant. Now you get it? I hope you learned a little bit more about overt acts and party admissions. You're already in this game, and it's a cold game. Whether we like it or not, we're in this game. You may as well learn the rules. United States.
Vicious work. Vicious work. So did anybody go over there and tell them that we over here on Lamonte Sims? They could keep watching that one, but we didn't really need to get back into that anymore. We're moving forward because we're gonna break this down. I think she has something else on Big U. We finna get into that real quick, and then I'm gonna break this down with the exclusive breakdown from Duse M's to Don.
Henley. So that's Big U, and I'm sure a lot of you already knew that because you're following, I see on all the YouTube channels and podcasts and so on. And in my opinion, there will be not one NBA or former NBA player that takes the stand as victim or as a witness for the prosecution. So I know many of you think that Draymond Green will be there, Shaq, Rajon Rondo, and James Harden. And in my opinion, none of those people will be victims on that stand. So let me know what you think about that. And let me know what questions you have about that case. United States of America versus you.
So let's get to the content. Duse M's breakdown. Salute, Southern Force. Salute. Let me get you up here, man, because I want to hear what you got to say about this. We just heard Attorney Jasmine talk about some other stuff related to the Big UK. Man, Big UK is going to be huge. When we looking at trial starting maybe next month, you know what I'm saying? So come on up, Southern Force. You know what I'm saying? Bang that like button if y'all just getting in. Welcome to the Damu Kiwe Conversations. I'm the host, Duse M, the Don. And we got the content. So I wait for Anad Muhammad. Salute, bro. You know what I'm saying? You still up in Fresno right now? If you is, salute to you anyway. If you ain't, salute to you. You already know, bro. But so check this out. Okay, I was waiting on Southern Force before we did that. Let me hear what's your reaction to what you've seen already today, and everybody's hitting that like button. Let's go.
Basically, what you've been saying for a minute. I mean, if they wouldn't, think about it, if the prosecutor wasn't making so much of an uproar about it, why would they have a issue of him summoning these witnesses? It's because of a simple fact: they're confidential source, i.e., this particular one is one of their main confidential sources. So when they start saying stuff like that, man, why else would you say something? So when I looked at it, I'm like, wait a minute. Then when you start underlining, I'm like, oh shit, that's what it was. Excuse my language. But I was like, golly. So basically they're trying to avoid from Wack going on the stand, but Big U and they team like, no. Those who said this and said that, and they need to show up. They need to show up. So it's like I don't know how many times you have to say this. How many times you have to go over the paperwork over and over and over and over again for people to realize, man, that man's a confidential source. He's working. He's no good for the community. He don't care about nobody but his own self, and that ain't good for a whole community, especially a person who has that type of platform that can influence so many people. This is nasty work.
I agree totally, bro. That's essentially what it is. So, Fan West TV, salute. We just put the thing in the chat. You come up here, I want you to catch it. So I want you might be able to bring him on when he come in, but if not, I want to get into this and break this down, right?
Right.
Did Big U lawyer just confirm the informant narrative? So, listen, this just changed everything because now it's not bloggers. It's not the internet. It's coming from inside the courtroom. Big U's own defense is now talking about an informant in connection to these wiretaps. And the question is, who are they talking about? Let's break this down clearly. You got two wiretaps being discussed. One where Big U allegedly says he wants to beat up Wack 100.
Right.
Another where he allegedly tells someone to stay away from Wack 100 because he's a federal informant. Now, the defense argues expressing disapproval of an informant in a private conversation is not obstruction, not witness tampering, and not a RICO predicate act. The key question. Now, let's stop right there because this is the part nobody can ignore. Who is the informant they're referring to? There's only one person connected to both of those wiretap conversations.
Facts.
Wack 100. Now let's go deeper because this didn't just come out of nowhere. On Clubhouse in the Damu Kiwe Conversations, Duse M was the first one to publicly raise questions about this. We discussed what was described as CS2 back. I'm going to take y'all back real quick, man. Let's get into this motherfucking content. Bang that like button. We cooking today, and I hope y'all enjoying the show. But I told y'all what it was.
Checkmate. Like I told you, bro, checkmate.
No, it's definitely
checkmate.
TV, man.
Previously in part 1, we found out from Robert Ross, also known
Oh, hold on.
Stutterbox, a Main Street Mafia crip and Wack 100's neighbor. That Wack 100 or CS2
Let me get up here.
back got his house raided for getting caught on a wiretap on a conspiracy to commit murder.
What is it exactly you want to clear out? And I clear it out, however it got to go.
On the video, when you said something about conspiracy to murder, what actually did you hear on audio of Wack 100 that the feds had, but haven't charged him for conspiring to murder?
His house got raided because he was on the wiretap with Dog. You know, he allegedly gave Dog my address, homie. If I get killed, whoever gave him my address gonna get conspiracy to murder. But if I don't get killed, they just get conspiracy to attempted murder because they shot up my Rolls Royce, put 17 holes in my Rolls Royce.
Let's play Stutterbox talking to Wack.
This is what I'm trying to figure out, though, Box.
help me understand this, because me and you both know that whole case was your thing. What is Mark saying I had to do with the case, bro?
Wack, listen, in the paperwork, it said you tried to call Dog, remember?
I tried to
And he
call
wouldn't take
Dog.
your call. And I sent it to you. Saying he didn't talk to you. He wouldn't take your call. Dog said he was cool. He didn't want to talk to you in the paperwork.
Mark
That's what
tried
Duse
to
is going off of. What
that whole Main Street shit, that was your play. I had nothing to do with it. I was a victim.
I was a victim. But you heard Stutterbox say that's what Duse M is going off of. The paperwork. I could show you the paperwork. So he got the same paperwork Mark Stevens got. That Mark Stevens gave me. Let's go.
Because they said when Dog called you, his phone was hit. That's how they got on your line.
No.
And you claim that's what they say, what?
No.
As you can see by now in this first part, Stutterbox clearly implicates Wack 100 into this case, not only in an interview with Duse M's and Stats 280, but also right to Wack's face on the recorded phone call. In part 2 of this video, let's take a look at the actual paperwork from the case, which exposes Wack 100 as a confidential source in the Main Street Mafia Crips case.
We're gonna get into the paperwork. The paperwork is a transcript of a wiretap. And once I get into this paperwork, you're gonna understand that Wack was one of the names that the feds used for confidential source number 2. So Wack also says CS2. Wack. CS2, for those who don't understand law, is code word for confidential source. But once I get into this paperwork, you're going to understand that Wack was one of the names that the feds used for confidential source number 2. So Tiny Draws told that nigga, you on paperwork, nigga. Yo, what's up, Wack? What's up, Wack? And didn't nobody understand why he was calling him back.
You lying. Are you dumb or something? How young back? Go ask your uncle if he didn't see my daughter. How young back? Let's talk about it, little back. Who's back? I don't know. You know who back is? I don't know. You know exactly who back is, nigga. I don't know who that nigga is. You know exactly who back is. Stop playing these games, nigga. Who that nigga is. You know about Marky Mark. You know about Stutterbox. You know about Dale Dog back. Stop playing these games, nigga. Stop playing these weird ass games, nigga. Yeah, stop playing these games, nigga. Hold on, what Stutterbox got to do with something? Yeah, you. Hey, what Stutterbox? Man, put that on Pyro. Put that on Pyro. That's gonna be another story we gonna talk about later. Hey, what Stutterbox got to do with something? He got. I'm talking about that paperwork, nigga. You know exactly what I'm talking about. You saying I'm on paperwork? Bro, am I lying? Put that on Pyro, you not. Wax on paperwork? Put that on Pyro, you not. Put that on 6-0 Wax on paperwork. 6-0 nigga, you on paperwork. Put that on Pyro, you not. Put that on. Man, put that on Pyro that you not on that case. Produce it. Put that on Pyro that you not on that case. You know I'm the one got told on, Put that on Pyro, we didn't make statement.
So Tiny Draws said that the nigga name was back and that he was on paperwork. Well, the paperwork is a transcript of a wiretap, and it's from Dale from Main Street Mafia case, rest in peace. So we goes to the first page, and it has the session 18202. This is the wiretap, date and time 8/5/2008 through 9/22/38 to 9/29/39. Duration so 7 minutes, 1 second. This is the feds breakdown. Dale tells Stevens that your boy Box, referring to Stutterbox, we can all agree to that, right? Went south. Back wants Dale's phone number. Back needs to talk to Dale. It's important. Back what? Right? But it also says CS2. Back. CS2, for those who don't understand law, is code word for confidential source number 2.
At some point, you get a phone call from Wack 100, Cass Jones. What did he contact you concerning?
He wanted to reach out to Dale Dog, rest in peace. I got the whole transcript, of the whole wiretap. Lawyers that was involved, they was able to get the discovery.
But when you get the discovery, was part of that the actual wiretap? Do you see your conversations with Cass Jones in them transcripts?
Paperwork, they put him as back. B-A-C-K. I kept asking the lawyer, like, who the fuck is, I ain't talked to no back. And they said, nah, that's Wack. But they put him as back because he a blood.
Was this back also referred as confidential source number 2?
Yes, sir.
So
You get into Dale talks about Box incident and Back wanting to talk to Dale. Wack wanted to talk to Dale Dog. Mafia talk and someone talking too much. Box with a question mark. Sound like Back, which is Wack, has info on Stutterbox and talking about phone lines being compromised. So Wack is wanting to talk to Dale Dog, so he goes through the Mafia's talk, who we gonna use
Mark
the Mafia
Stevens.
talk for this, not to involve nobody else, right? He tell Mafia talk, look, I need to talk to Dale Dog. That nigga Stutterbox went bad. Well, Wack knows Stutterbox because that's his neighbor. In fact, that's how Wack even know Dale Dog. So the only way you would know that the wires is tapped, and the only way that you would know that Stutterbox had went bad, nigga, is if you done went and talked to them people. Wack admitted that he did go talk to them people on the 64th floor.
Raided my motherfucking crib, didn't find nothing. Cut my wife up, searching, going through everything. They ain't found nothing. When I went down to the federal building, my attorney to get my shit they took out of my office, every bitch was on that floor with FBI flak jackets on. That's the first thing I saw. I'm like, damn.
It goes into saying Box punked the gang. 2 messages on Mark's phone. Mark is involved on the gang business and operations. Duke. Back is calling on another line to Mark. It says, hit me about 3 times. He want me to give you a number, so I'm calling to clear with you first before. So Dale Dog was like, I'm cool on that, brother. Right? Nigga, he don't even want Wack to know his number. So the nigga Mafia, he come back and say, oh, okay, you don't want? All right, so you don't want to do no hollering, all right. He said, what's up with you though, man? Dale Dog changed the subject. So the dude Mafia style say,
Mafia style was Mark
we'll
Stevens.
talk, man, you know, I just need to know, man, and you, when I talk to Back, which is Wack 100, I'm just gonna tell that nigga, man, oh man, well, you know, homie, you been on the phone with Dude, and you know, like basically you been on the phone with Stutterbox, and you know, like, you know what? I'm saying you right, man. No telling what lies he told a nigga on the phone. You know what I'm saying? So they already own Stutterbox and Wack 100. And then also this Dale Dog. And then when you call the dude, you make the dude talk about certain stuff on the horn. You know that's what they got going on. He talking about Stutterbox and Wack 100 got that going on. I ain't got no time for this dude. So then Mafia style say, I mean, you know that's good information. See, now I know how to, like I said, I ain't helping the Wack boy in a minute. You know what I'm saying? He called me out of the blue yesterday. Not yesterday, last night. Left me 2 messages. And this morning. And I just need to know how to play it cool. You know what I'm saying? Nigga probably said, man, nigga going to jail, you know? Laugh. The nigga got to laugh. So that's the first page. Hold on, we ain't finished. We got some more shit that's gonna talk about that. Or confidential source number 2, aka Wack 100.
It ain't no way we
next page with other leaders of the Lord's Gang organization.
No, Greg Katie won't give it, but we live, so hold up.
Committed by the Main Street Mafia Crip, including shootings, burglaries, and murders. Confidential source 2 is unwilling to testify in court against members of Main Street Mafia Crip because confidential source 2 is fearful of retaliation against confidential source 2 and or confidential source 2's family. Tiny Draws called that nigga back.
Nasty work. The nastiest work I done seen on the internet.
Because he already has seen this, bro. That nigga wasn't capping, and he knew he could stand on that. Wack 100 is confidential source number 2.
They put him as back.
BACK. I kept asking the lawyer, like, I ain't talked to no Wack. And they said, nah, that's Wack. But they put him as Wack because he a blood.
So we're going to get rid of that. So we done with that one, right? So as I was saying, before I went into all of that, let me put this back on, right?
Right.
So so that was the Clubhouse moment, right? I exposed CS2 back, and the next thing I know, within 10 minutes of me coming with CS2 back wiretap paperwork, this nigga had 2 ex-law enforcement officers, Detective Greg Caden, who was the head of he was an LAPD officer, but he was the head of the Federal Joint Task Force, the same Federal Joint Task Force that indicted and investigated Big U in this case, the same Federal Joint Task Force that investigated Death Row Records, Suge Knight, in the Biggie Smalls murder investigation. And we ain't gonna listen to all of this, but in 10 minutes, he was able to get Greg Caden and another known informant, Reggie Wright Jr., pork butt, allegedly. Let's listen to it. I'm gonna take y'all back. Y'all act like y'all don't be remembering.
Investigator, I'm probably saying this shit wrong. You take one on that case, to where Greg, well, fuck it, Greg, tell them who you are.
That's funny. So yeah, I was a cop in LA. I ended up working on Tupac and Biggie's murder investigations back in the 2000s, and then I left and wrote a book about it called Murder Rap. So yeah, I had an opportunity to kind of like dive deep into all of the different theories and accusations and ideas behind what had happened with both Pac and Big, and that's it.
All right,
And that's
so,
it.
Greg, Reggie sent you a document, and I'm looking at that and looking at the names. MS, I'm identifying that as Mark Stevens. DD, I know is Dale Dog, and they got a name on there called Back, BACK, and it has some shit. Let me pull this shit up so I know what the fuck I'm talking about. Back, and it has some shit says CS2. Now, can you tell the people what my position in this case? How did Cash Jones, Wack 100, how did I get involved or implemented in this case with the Shutterbox?
Okay. So it all started when there was an FBI agent who told us that he had an informant that could potentially give us some information about Suge Knight that may help us further our investigation into the murders of Tupac and Biggie. That's
that Stutterbox, Wack 100 right hand man tells them that Wack 100 could give them information about the murders of Tupac Shakur and the notorious B.I.G. Christopher Wallace. But 10 minutes, he got the Federal Joint Task Force on speed dial. He said Reggie Wright Jr. It was Reggie Wright Jr. that got me up there. That got Greg Caden up there. we still going. So everybody on YouTube just coming in, y'all could go on YouTube or Twitch at Active Chucks. So let's get back to this what you call it. So there's the Clubhouse moment. And the people remember this. Within minutes of those accusations of CS2 being made publicly, Wack 100 had 2 former law enforcement figures come onto the stage defending him. That raised even more eyebrows and questions because the police can't vouch to some street niggas that you're not working with them. Now you're overly familiar, right?
Right.
So then I interviewed Money Mark Stevens, and I interviewed Money Mark Stevens, and I interviewed Stutterbox, the victim, Robert Ross. Matter of fact, let me take y'all back to that for those who don't remember, right? And we made this a video, and I distributed it through World Star Hip Hop. Y'all turn on y'all seatbelts, get your popcorn and a Snicker. It's gonna be a little while. Let's go.
Yo, it's Duff for the Cloud Chaser TV. Man.
In part 1 of this case, we learned from Robert Ross, also known as Stutterbox, a Main Street Mafia Crip, and Wack 100's introduction into the case, that Wack 100 or CS2 Back's house got raided for getting caught on a wiretap on a conspiracy to commit murder, which he never went to prison for, according to the paperwork.
On the video, when you said something about conspiracy to murder, what actually did you hear on audio of Wack 100 that the feds had?
His house got raided because he was on the wiretap. He allegedly gave Dog my address, homie. If I get killed, whoever gave him my address gonna get conspiracy to murder. But if I don't get killed, they just get conspiracy to attempted murder because they shot up my Rolls Royce, put 17 holes in my Rolls Royce.
That's what I'm trying to figure out, though, Box. Help me understand this, because me and you both know that whole case was your thing. What is Mark saying I had to do with the case, bro?
Like, listen, in the paperwork, it said you tried to call Dog, remember?
I tried to
and he
call
won't take
Dog.
your call. And I sent it to you because they said when Dog called you, his phone was hit. That's how they got on your line.
No.
And you play. That's what they say, what?
We will get you 1 million views or you don't pay. And if you give me 15 seconds, I'll explain exactly how this...
Damu Kiwe Conversations. Let's get back into it, man. Pardon the interruption. Hit that like button.
As you can see by now in this first part,
Share that Cash App is
clearly
open.
implicates Wack 100 into this case, not only in an interview with Duse M's and Stats 280, but also right to Wack's face on the recorded phone call. In part 2, we saw Duse M's break down the paperwork with the transcript on which Wack 100 or CS2 Back was caught red-handed as a confidential informant for the FBI, with detailed corroborating evidence and paperwork that leaves no doubt that Wack 100 is in fact confidential source number 2 or CS2 Back.
The paperwork is a transcript of a wiretap. And once I get into this paperwork, you're going to understand that Back was one of the names that the feds used for confidential source number 2. So Back Wack also says CS2 Back. CS2, for those who don't understand law, is code word for confidential source. Wack 100 being on a wiretap talking about conspiracy to murder. That holds the same exact time as a murder, a life sentence. And if that's what you on wiretap for, and if that's what they came for you for, then how you out of jail?
In part 3, Duse M's and Stats 280 speak exclusively with the last key remaining character in this case, and the person Wack 100 directly calls on the wiretap, according to the paperwork, Money Mark Stevens. In this bombshell interview, Shaq's business manager Mark Stevens exposes Wack 100, aka Cash Jones, the former Death Row affiliate and Pacoima Piru blood, as a confidential informant for the FBI.
What's going on? I'm here.
We got Mark Stevens on, and
Okay.
hey Mark, can you hear me?
Yeah, I can hear you. Can y'all hear me?
Yes, sir.
Yeah, we can hear you. Salute Mark Stevens. This Stats 280. Salute everybody. Salute. Yes, sir.
So you was cool with him from the beginning, even negotiated on some business as he.
Yeah, I met him. I met him with Stutterbox. I met him with the homie Stutterbox. That's how I first came to meet Wack, was through the homie Stutterbox. Right? When I met him, dude was driving trucks, seemed to be cool.
Yo,
I
what
was
up?
like, yo, this was his neighbor across the street.
He seemed to be cool. When Stutterbox defected, when he defected, Wack picked up the phone and was basically being the interim, the middleman, because he was telling me Stutterbox was defected, and I was like, okay, but my whole thing is if he defected, why are you fucking with him?
Right. So he says that Stutterbox defected, and then you get some phone calls asking to speak to someone else, right?
Yeah, he called me. He called me, man. It was, man, a series of calls, 4 or 5 calls. He wanted to reach out to the homie, rest in peace, Dell Dog. And I don't give out nobody nav. So I called the homie, Dell Dog. I'm like, yo, homie, you want to holler at this dude or what? Because he keep calling me. And he was like, nah, I'm good on that. I don't want to holler at dude.
So at some point, you get a phone call from Wack 100, Cash Jones. And when he contact you, what did he contact you concerning?
He wanted to reach out to Dell Dog, rest in peace. And he wanted to give Dell Dog some information that he had gotten from Stutterbox, right? It's like he was getting information from Stutterbox on what his plan was and what the get down was gonna be. And he wanted to talk to the homie and talk to him. And Dog wasn't getting on the line with him. And he kept blowing me up because he wanted me to get him on the line.
Right. Smart man. Rest in peace to Dell Dog, man. So he's talking about the phones is being compromised. Is that one of the things that he told you?
Well, the homie Dell Dog never trusted dude. You follow me?
Right.
So Dog didn't know was the lines compromised or was they wired up for sound or not. He just wasn't gonna chance it. You follow me?
Right.
But it was later on. It was later on after they took the case to they was taking it all away because the homie ain't had no choice. You know, he was facing a life sentence, so he had to take it all away. And with all the lawyers that was involved, they was able to get the discovery, and that's when we found out that the lines was compromised.
And as soon when you get the discovery, was part of that the actual wiretap
the whole transcript. I got the whole transcript. The whole transcripts of the whole wiretaps.
And do you, in that paperwork, do you see your conversation with Cash Jones in them transcripts?
That was the initiating. That was the initiating when they started recording.
Right. And how did they refer to Cash Jones?
In the paperwork they put him as Back, B-A-C-K. And
correct.
I kept asking the lawyer, like, who the fuck is? I ain't talked to no Back. And they said, nah, that's Wack. But they put him as Back because he a blood, so it's Back. And I said, oh, okay.
And was this Back also referred as confidential source number 2?
Yes, sir.
Correct. Well, man, I'm glad that the truth was able to come out. And it's sad.
But bigger than that, homie, right? I watched dude, man. He said some things about the big homie Shaq, that wasn't true. He said some things like he been trying to destroy the big homie Big U name. And I'm seeing and watching this, and I called the big homie U. We was talking. I said, yo, when you get into Atlanta, man, come see me. Because I had what I had for years. And when I gave it to the homie, I said, man, you read it. Because it was a big-ass textbook of shit. And the homie just sided with what was right. He said, I can't fuck with dude no more. And that was the end of that.
Until Wack started attacking, and that's when Wack started attacking him with false allegations and all of this online weird shit, right?
Correct, because because the homie Big U asked me why I didn't fuck with the nigga, and I said, when you pull up, I'm gonna show you. I want you to read it. And when he read it, he was like, oh, okay, I see why you don't fuck with the nigga. I can't fuck with the nigga. And that was it.
Wait, how long was it from when you first got it that you let you in Atlanta to show him the work?
I got the paperwork from the attorneys probably in...
This sock brand turned on one new channel and it became their most efficient
Conversations. This is nasty work. So these niggas out here is really protecting this rat.
Acquisition tool.
Right? These niggas is harboring this rat. These niggas doing business with this rat.
13,
but these niggas supposed to be gangsters. Tell that to somebody else, bro.
06, but
niggas is
went
busters.
to prison. He called a drug case, so he went to prison, and they waited to almost the last month of the statute of limitations to go get the homies from Main Street. Right. So it had been about a 5-year period from the time that had happened to the time that they came and got the big homies. And then once they got...
How did you feel about you waiting that long now?
Well, he chastised me, and, I never, one of the things, bro, and it's like it's the slippery slope, as people say, right? Like, on one end, Wack, the nigga, he wasn't doing no harm, right? He was just trying to move around and be the tough guy. Okay, cool. You know what I'm saying? My whole thing is, okay, that's what you want to do, cool. But then it went from that to, I heard what he was saying about the big homie Shaq, and then I heard what he said about Big U, and that's when I picked up the phone. I said, hey, you, man, I want you to read something, man. And then once you read it, once you know, that's Quran. That's the Holy Quran. Once you know, you're accountable for what you know. And when he read it, he said, okay, I see why you don't fuck with dude. I can't fuck with dude. And that was it. Let me tell you something, man. I probably haven't seen nor talked to Wack in years, And, I wish everybody success and happiness, but not on the basis of lies.
Right.
And
not on and really indicative of your character, Mark, because you have a whole campaign publicly of a brother that's heavy in our community positively, helping get these kids graduated from school and into football and all of these other positive things. And he smutting his name through the mud just because he decided not to deal with it.
And brother, well put. Look, I call the homie Big U all the time. I call him the naked truth. And he always be like, why you call me the naked truth? I said, because Wack is the well-dressed lie.
Bitch, I'm naked right now.
It's an old parable about truth and lie when swimming. And, lie jumped out the water and put on truth clothes. So you had a well-dressed lie, but then truth got out the water and it was naked. So you got the naked truth that's trying to run down a well-dressed lie. Feel what I'm saying? Throw a rock and hide his head.
Right. That's a familiar tactic that he used. But we needed to get the truth where truth appears, falsehood disappears, man. And I wanted to hear that for myself, man.
Man, hey, man, I appreciate you, man. And, God bless. But like I said, man, it's a lot of things is just a well-dressed lie. That's all I can say.
Right. And that's what Cass Jones is. He is the well-dressed lie.
Yeah, and Big U is the naked truth. It is what it is. He always stood on the side of truth. He ain't never wavered from that. From the time I gave him that paperwork, I watched him take assault after assault because he just did the right thing. He just said, I can't fuck with you.
And I'm so glad that he ain't responded publicly to these negative lies because he's above that shit. Let him stay low and you just stay high. Don't let this man trick you up off the street or the feeling like you got to address every lie he makes up every day.
Well, and then you got to understand too, bro, it's, like I told you about throwing a rock and hiding your hand. What's the motive for throwing the rock to begin with? Like, we know the rocks is being thrown, but what's the motive? Like, only thing I saw the homie Big U put out a great documentary on hip hop. I see him, man, putting these kids through college and sending them like I'm trying to understand what's the motive, or it's a motive that we can't comprehend because we don't think on those levels. You feel me?
Hey, that's perfectly said. And I'm gonna tell you this: in all of my life, being from the community of South Central Los Angeles, only time I ever heard of a public artificial dissemination of disinformation was through COINTELPRO and J. Edgar Hoover, man. And
So there it goes there. We did that. Exposed that shit. You know what I'm saying? What up, Sonia? So this gets so nasty, it just never stops. We told y'all about all of that. We put out the documentary, Wack 100 and the snitch allegations, 3 million views in 3 days. And Wack 100, a hit dirt, they say only a hit dog holler. You know what I'm saying? And he couldn't stand for that to be on World Star Hip Hop. So he utilized his resources and relationship with lawyers and law enforcement and got filed a cease and desist and then filed allegations of defamation against World Star Hip Hop. He says he won, but all I know is once the appeal was up, he said he won, but he ain't shown us. He just could have settled out for $1 behind closed doors just to save face for all we know. Why you ain't shown your settlement agreement? I could show you mine against YouTube. You know what I'm saying? I mean, where's your settlement agreement at? If I could show mine, you can show yours, right? But 3 million views in 3 days on World Star's platform as well as his YouTube together. And then it was followed by legal action. So this narrative obviously and clearly hit a nerve, you know what I'm saying? But then over time, more things entered the conversation. Associations with individuals later tied to other federal cases. His Texas gun case, where we talked to Debbie Does Dallas. Shout out old Debbie. You know what I'm saying? And Wheeler County, Texas. Right?
Right.
Trafficking weapons cross state lines. And after 6 years of fighting a gun case, not a murder, a gun case. Do you know the YSL case itself took about 5 years?
Mm-hmm.
Wack 100's gun case, trafficking guns, took 6 years. And after his motion to suppress was denied, after 6 years, the case was dismissed in the interest of justice. A month after Del Dog and the Main Streets were charged for the kidnap, assault, and robbery of his neighbor, Stutterbox. So then he had claims of prior knowledge of indictments. Big U facing indictment. He got a RICO. This was 2023. How do you know about a RICO before the RICO dropped? It's not even public record. How do you gonna tell someone about a RICO when it's sealed until the grand jury vote and then it gets dropped? Public statements about interactions with the federal authority. Oh man, they owe me a favor. I saved Shaq in the Main Street Crips. I'm the one that saved Shaq in the Main Street Crips. Appearances in reports, interviews, and online content. Again, these are claims, timelines, and public discussions, not conclusions. But let's bring it back to the courtroom. But now, this is no longer just internet talk. This is now part of a legal argument in federal court. The defense saying this is just someone expressing disapproval of an informant, saying that Big U phone call about wanting to beat the Wack 100 ass is just someone expressing their disapproval of an informant. The real significance is that that's huge, because it means the concept of an informant is now being used in connection with these conversations in a RICO case. So the big question now we ask is, how far does this go? When did this alleged cooperation begin? Who knew what and when? Most importantly, is the courtroom about to validate what was once just dismissed as a rumor? What was dismissed as that nigga just hating on Wack 100? Is the courtroom about to validate that? That Wack 100 all along was confidential source to Back. He helped assist the death row investigation with the Joint Task Force. He assisted in the Main Street case, and he participated and helped orchestrate by third-party cooperation with Loose Cannon, Dale Morrison, and Marley Marl. Is this the reason Wack 100 moved to Utah? Utah! The NBA players say that's the worst city that they go play in. Why is Wack 100 and R&B moving to Utah? Big UK trial is about to start in May, next month. This is a developing situation, and we're going to keep breaking it down in real time. I need to hear from y'all. Is this a stretch by the defense, or did they just confirm something major? Make sure all of y'all like, hype me up, subscribe, tap in with the Damu Kiwe Conversations. Because we don't follow narratives, we break the news first. You want to say something, and we're going to let the people on Clubhouse speak on it, Southern Force?
Yeah, man. Like I said, this is nasty work. You've been telling us this whole time, you and amongst some other people's on Clubhouse. It's like sometimes I be feeling like it's our fault because we let it get by and not take this shit seriously. You know what I mean? On that paperwork, it clearly states that he is the confidential witness. You know what I mean? He even showed you that when he was doing open source intel on Clubhouse, open source intel on every social media platform that he can get his hands on. And all we had to do was just follow the breadcrumbs, and it led you right to what the court's been telling you. He is our confidential source. He is our beacon of telling, and we want to keep him nice and comfy in the interest of justice. Will it text and stuff, please? You know I'm born and bred. There's no way in hell, a black man is going to get through Texas, cross through state lines with guns. No way in hell. And you got priors too? No way in hell. So, like I said, you've been saying this whole time. Everybody thought you was hating on them and all that stuff, but it wasn't you. It wasn't just you saying this, dudes. It was multiple people, and it just started as a chatter. Then it just rose into a loud megaphone, and now it is what it is. He is CS2 Back confidential source. There's no getting around it. None. No narrative spin. This ain't no social media cleanup. It's who he is in real life. And that's what that is. I'm going to land that one.
I'm quite sure he was, but I'm not 100% sure he was, right? But that's a hell of a question. You know what I'm saying?
Second, I got. Listen, dig this though. You know I got this because I sent it to you, Messy. You know I made him tell me what he said when he went up to that fourth floor with them detectives or whatever floor he went up to.
He said the 64th floor, but it's only 17.
I got him on tape saying they asked me about the Biggie Small shit. I'm gonna send it to you. Well, Messy already got it.
Hey, Messy, send me that right now.
It's the one I sent you. Now listen, Duse M, we went at it for 3 hours, and he didn't want to answer none of my questions, and he didn't even put it out. He didn't even allow Ray Gibbs to put it out. But Messy got it. I sent it to Messy. We ran a big ass room on it.
Resend it to me because I
got it's in your messages. I'm gonna tell you where it's at. I'm about to go through it. I'm gonna tell you where it's at.
Okay.
Oh man, yeah, send that. And what was the third question? That's only 2.
The third one is I need his paperwork because I need to read over that work because he sent me some shit. I'm gonna send it to you. He sent me some made up shit.
Wait, from which case?
The whole time I was just spying on the nigga. I wasn't trying to be cool with the nigga. I was spying. But he sent me some shit that he made up and said, yeah, tell him to read this. I'm gonna send you that too.
What case was it?
He sent me some shit. Remember, you kept telling him to go get his case. Now remember, you was reading out the Texas case to him.
Right.
You was telling him read it out, right? I need to read that. I need to read that for myself.
Oh yeah.
So I've been trying to get Messy to get that from you.
Yeah, send your email. I can send that. That's one email. I can send you that. They got 6.
I give you my email, but you can send it to Messy. Messy got my number too. So, but listen though, when I was talking to him, he didn't put none of this whole. I'm gonna send you the whole shit because I was fucking him up doing the whole shit. But the whole shit, he didn't put it out. He didn't allow none of this shit put out. And I got him on tape betting me 10 stacks saying he didn't get knocked out. And you know I played when he got knocked out.
Rich Dollar, get your bitch ass up out of here, nigga. Didn't you just remove me from your motherfucking room? Now you over here ear hustling with a cock in your mouth. Nigga, get the fuck up out of here. Dick sucker. All right.
You gotta send me that paperwork.
Oh yeah, I get.
Because see, he told me. Remember when I was? Hold on 1 second, Scout. You remember when you was talking to him about the detective saying he smelled weed and all of that?
Yeah.
He tried to say none of that happened. Nigga, that's the probable cause of them searching your car, nigga.
Right.
That case didn't go away. If you had a technicality, they would have threw it all away. But they ain't gonna throw the guns away because you cross the state lines. They ain't gonna throw that you were convicted felons with guns and around guns. And you got motherfucking Kill Bill in the car.
Right. And his brother on probation.
Right. So you sitting up here telling me, now this is what he told me. I'm gonna say you all the shit. This is what he told me. I wasn't never gonna go to jail, Scott Walker. You know my brother was gonna check the rap. We don't care about that, man. We care about you taking 6 years to beat this case. It don't take 6 years to get something in the interest of the law. And then I turned around and said, if that's the case, my pops did too. Messy was on the phone with me. I had to kick the nigga Wack off the phone line. It was me, him, my dad, and Messy. My pops did 10 years in Texas. Ain't no way he could have got out of that case, nigga. You was a convicted felon crossing state lines with guns, with bullets. You in violation both ways.
Right.
So ain't no way you can say, well, yeah, I beat it. No, you beat the charges on the interest of the church, on the interest of the court. And if you beat the charges like I told him, you would hear me say it during the recording. If you beat the charges in the interest of the court, why can't nobody else get that?
Right. Yeah, this nasty work. So for those who said that's in the comments that said that Big U lawyer didn't refer to Wack 100 as the informant. Shortstop in the Field podcast said he not confidential no more. He is human source 2, HS2 back. You know what up, bro? What up, bro? Man, this shit is, bro, this shit is so nasty, nigga. He told me when I first met the nigga on the app, the nigga said something about he said, man, these niggas put the police on the enemies, and it rubbed me wrong. Like, damn, where did that come from? We talking about something totally different, and you talking about niggas putting them. So I'm like, man, this nigga must think like that. But look, overt act number 164. It's on the screen on YouTube. Exhibit C58 to C59 on January 12th, 2023. On an intercepted call, defendant Henley said he wanted to beat the shit out of Wack 100. Big U's lawyer, the defense response, said the government has not identified what action, if any, was followed because none did. Expressing disapproval of an informant in a private conversation is not obstruction of justice, witness tampering, or RICO predicate conduct. Do y'all know what that means? ChatGPT told me that means they're hey, Fox, what up, bro? Pull up.
Fox and that truck.
That nigga said, that ChatGPT said that Big U said, don't mess with Wack 100 to Marley Marl and to Dale Morrison. He said, because Wack 100 is a federal informant, right? And so they both ran back and told Wack 100 what he said. So ChatGPT said, so who is the informant the lawyer is referring to? They are clearly referring to Wack 100. That's the only person mentioned across both conversations that connects the dots. Wiretap 1, Big U allegedly says he want to beat up Wack 100. Wiretap 2, Big U allegedly tells someone to stop dealing with Wack 100 because he's a federal informant. So Big U lawyer was referring to the informant, Wack 100. This is nasty work. Anybody else want to speak on this shit?
Duse M. Yeah, he dirty all the way around. I'm looking for this recording right now. Hold on.
Oh yeah, I could wait for that. Oh man, because I showed
300 numbers. I ran it in Bugatti room. Man, we ran that nigga off the app, nigga. He bet 10 stacks. Hamburger Chuck bet 10 stacks because we was on the phone together when he bet that he owned this shit, and Wack turned on him and said, "No, I own your shit." Foreign, not domestic. But
I remember that.
He didn't touch the channel, but yeah, you remember that? Yeah,
I remember that. Yeah, Skywalker.
Yeah,
that's me.
Yeah. Oh yeah, I remember it.
Yeah, he owed me 10 stacks, but hold on, I'm gonna find
it. They said nowhere does the government reply about him not being an informant. I got the reply. I didn't find nothing where they said he wasn't an informant, but I got the old stuff. Remember when they said we've never talked to none of those guys Big U said when he was turning himself in. When they the Crip cop was like, the U.S. attorney cleared me, Wack 100, and Eddie Boy. They've never talked to us.
Duse M's, he got that badge. You know what that badge means?
What?
He's a friend of somebody that's on law enforcement. That's what the badge they give you. So if you get in trouble, you show them that badge and say that you working, you doing something to work with the police. That's what that badge means.
Yep.
Right.
Remember, bro, on Instagram, when I show you that clip on Instagram, and the old boy who was in the hospital pulled that out. That's exactly.
Oh yeah, I remember.
That's exactly what it looks like.
Oh yeah, man. Damn, this nigga went out like this.
These niggas got honorary badges, but
hey, honorary badges, nigga. CS2 badges. He don't just got one honorary badge, nigga. That's CS2 badges, nigga. He had the gold one at first, then he doubled back trying to cover up with a chrome one. You know what I'm saying? Nigga,
got promoted or promoted.
Man, you heard what that nigga Brick Baby said. He said when that nigga was in that parking lot, That nigga pulled out Billy Western in one hand and a bust down wallet. He said, niggas got bust down wallets. Capiana, nigga, you the police. Nigga pulled out a badge and a pistol.
Well, that's the best way to say that.
Yeah, nigga. Imagine, why would you be pulling out your wallet anyway? Right? In case it go down, you pulling out Billy Western, but then why would you pull out your wallet? Nigga, it had to be freeze. I'm the police. He identifying himself. You know what I'm saying?
Make your move.
Don't make me shoot. Yeah, I'm saying. Hold on, let me get this last thing. Let me see. Active Chucks. Brick Baby says Wack 100 has a badge. I'm waiting on Skywalker. That audio from Skywalker pressing the nigga.
Yeah. Bust that wallet, golly.
I can drop it in the chat.
Yes, sir.
Uh-oh.
Uh-oh.
Got it.
I'll go to the timestamp to see exactly where it's at. I think it's the last 3 minutes of the show. If you want to start before me, it's the last 3 minutes.
Oh, yeah, we can go there. Hold on. Let me get that. Oh, yeah, it's already in the chat. Oh, this is nasty work.
You know my nigga Walt, stay with the word.
Hey, this is the end of CS2 back. This nasty work. Damn. That nigga said he admitted the shit about that they asked him about Biggie. That nigga fucked up. Damn, it say get the app because it's on
hold on, that ain't it. Hold on. Damn, I can't believe Messi don't remember this shit, man.
Oh wait, you saying that's not the content?
Yeah, that's not it. I gotta find it. Hopefully they didn't take it off. Hold on.
Ooh wee. I thought that was that shit. That's that shit.
Boy, that bust down wallet. I ain't gonna never
Wack 100. I'm not a witness in the criminal case. That nigga don't do good on defense at all either. This is going bad. Man,
bust you good on defense when you've been a water boy. Shit.
Okay. Oh, hold on. Let me see. Brick Baby says Wack 100. Brick Baby Wack 100. Maybe it'll pop up like this. Novo. Because that was at the Novo. So maybe that'll come up. Brick Baby said Wack 100 was involved in Pooh Rider's death. 30 days to produce a statement. This might be it. Hold on. Y'all gotta bear with me with this though. We finna get this though. Watch this. Well, people, the good people, Big U good people's text me said they knew that was coming. You know what I'm saying? Nasty work. Nasty work, bro. Wait, what's this?
Man.
Damn, where this shit break at? And I'm waiting on it.
Is that why he was getting ready to make his plans to go to Utah? He left from Vegas?
No, he already went to Utah. Nigga, he there. He's gone.
No, I'm talking about that. So beforehand, remember he was still in Vegas when all this was going on. But soon to get closer and closer, he had to back up the Mayflower truck. That's nasty work.
Man, that dude right there, bro, he going down in snitch history. Remember he said he wrote a book when he got out of jail called infiltration.
He did say because he was talking about stuff like the Art of War and Lao Tzu and all that.
You see what I'm saying? Well, this might be it. Okay, so that was the Iron Donkey. Okay, that was me, Rockstar, and Brick Baby.
I got it. That's it.
Right. Tell me when it's in the chat.
It's at 6:33, I think.
In the one you just put in the chat, or
Yeah, it's a long room. You know, PTK rooms be long as hell, but it's at 6:33, I think.
oh
Hold on,
yeah,
let me double check.
oh this is gonna be nasty work. Oh, it was the other link.
Yeah, but you gotta know I left because the nigga started trolling after I got him together. So I left out the room and she was speaking. But I'm about to give you the timestamp though. That's the room though. Hold on.
Oh yeah. Wait, we got the app. Oh, they knocked me out the damn room. Hold on. Damn. I can't show it like this. How can I do it?
Do not let the mods leave.
Damn, I done left up out the clubhouse room and went to the link. My bad. Hey, bro, I hit the link on my phone and that motherfucker took me. I hit the link on my phone and it took me out the thing.
Oh, that's right. To take you directly to the replays.
Yeah, but that's okay. I'm finna figure this out on this what you call it. And he was telling me, man.
6:23 is the timestamp.
Okay. Scan the QR code to download the Clubhouse app. Okay, so how do I scan the QR code? Boom. I don't be using it on my thing. Boom, Clubhouse. Bam. And then it's going to take me out again. They tell a bitch, I don't want to get taken out. They keep doing me like that. They keep taking me up out of there. Copy link. No, what I got to do is get Stream Deck, right? I don't know. It's I could play it on mine and you could play it on his. Everybody I sent it to because I sent it to him directly. Yeah. Oh yeah. Go ahead and play it then. The speakers on. I can't play it because I don't got a second phone. Let me see if I. No, you can. It'd be loud if you play it just on this phone because the speaker is on. Make sure you got the radio speaker on. Hold on. Let me see. Audio. Go to audio quality and then turn on music. And then you put mute. Yeah, music. It's gonna take me out to a room though, ain't it? Nah. I'm going into the oh yeah, it's still gonna take you out the room. You right, bro. So I need to send it to somebody. Messi, he could play it. Messi got it. I can send it to him again. He got a second phone. Man, Messi don't know how to play no. You know my brother is old as a motherfucker, man. You know what I'm saying? That nigga ain't. Yeah. But you can why you can't take it from the Google and like download it to your thing, to your laptop or whatever. Oh, to my phone, huh? Yeah. I don't know how to download it to my thing. Hold on, I'm finna try to download it right now. Hold on. Let me see how this goes. Oh, Miss Mo. Bam. Okay, so how do we download it? Nah, it's still not going to. Do not. Oh. Oh yeah, niggas got a long night tonight, fresh. Maybe if I sleep, I get a bean. Maybe if I put it on. I don't got work tomorrow. It's good. Maybe if I post it on. She back. Oh my god. Marcus down there. Marcus got an arm coming out of his back. Hey, must like money. Hey, must like money. Okay, so we gonna close that shit off, and then I'm gonna go back to the thing. Man, we working hard for this content right here. All right, let's see where we at. Facebook. I'm trying to 23. All right, hold on. Let's go. I shared it on Facebook. Boom. Clubhouse speak. And it's still talking about get the damn app, man.
If it say get the app, hit the button. You gotta press get the what you call it, and the room gonna come up. That's what they try to do to get you from playing it.
Oh, so you said hit what button?
Hit get app, and then when you see that, hit the circle, because that's the file that it's in, and then it should come up. The room should come up.
Yeah,
you see
nah.
That's a replay, Walt? Yeah, it's a replay. You can do it, Matter Mike. I know you got. Just need another phone. That's it. No, you can get it out the goo. I can send it to you. You can get it out the goo. I got another phone right here. You got
Good looking out.
What I need to do. So you want me to? You got give me take my number down, and that way I'll send it to you directly to your phone. All right, I'm finna back in. All right.
Oh yeah, we got the content.
We got you.
Welcome to the Damu Kiwe Conversation. This is the rise and fall of Wack 100, CS2 back. Today, we broke down and read Big U's lawyer's motion about what evidence is going to be admissible or not. And during that, Big U's attorney fingered Wack 100 as and categorized him as an informant. This is huge. How many other of these so-called dudes in hip-hop culture are working with law enforcement right up under you, playing like they gangsters, playing like they street niggas? You know what I'm saying? But they working with the police, getting up under you, gathering intel for a check. This is nasty work, bro. This is nasty work.
Hey, dudes, bring bring Joe up down there. That's the audio.
Okay. He up.
Hey, send it, Walk. I'm ready. I'm out you right now. I just got your number.
Boom. Hey, I got something for y'all. We can play this while we waiting. Y'all tell me when y'all ready. We got this right here. It's Future. I know they not gonna let me monetize, but that's okay. Pop Smoke and Future. Let's get this cracking. Tell me when y'all ready though. Oh, y'all don't know about this? Hold on. I want y'all to tell me if y'all know about this though. You know what I'm saying? We ain't talking about Geico. We talking about Gecko. You know what I'm saying? Damu Kiwe Conversations. Let's turn it up.
The Mad at Mike. So it's at 623, Mad at Mike. I had this nigga on the ropes, nigga. You gonna see me play the audio of him saying he got hit in the mouth, nigga. You got that audio?
Hell no.
Yeah, I got that, nigga.
Oh, wait. I got him talking about he got hit in the mouth with Jason Lee.
Yeah, that's the one I played with him. He bet me 10 stacks on that.
Oh yeah, that's what he was trying to bet Imam today.
You said what?
Today, that's the same bet he tried to bet Imam today.
Yeah, see, I bet that. He won that, and everybody said I won that when we did the second room. And he ran from that. Same thing Chuck did. He probably trying to get his other phone, huh? When he going to get his other phone to do that. Yeah, but you're supposed to be able to get that because that's what it say. It say you got to get the app. But you press that blue button and the whole page come on. You can see the whole PTK room. I don't know why. Did you press that button? Did you press that get app?
Hell yeah, I kept pressing it.
When it started. 623.
Oh yeah, we on.
Give me a second.
Oh yeah, we on.
Yeah, I pressed that nigga for 3 hours, nigga. You ain't up. Watch y'all do this nigga. I pressed this nigga for 3 hours in PTK, nigga. My ops room.
Let's see what we got.
Made that nigga talk about everything, nigga. Everything. His case in Cali, everything, nigga. I told him, CP case, I pressed him on that.
Oh, I think he playing the audio. Was that him?
Yeah, he ain't even off of mute yet.
He might.
Man, y'all bang that like button, man. Bang that like button, man. Let's go.
Yeah. Now go ahead and play it. Let us hear it.
All right, hey, mute up.
All right.
Y'all hear?
Yeah.
Turn it up.
This nigga's a snitch's right advocate. So he do got his name expunged.
Okay, but you got the death row to Reggie, right?
This is a lie. K9 already exposed. He wasn't a part of that fight. Hey, this is getting late. We finna get ahead and get off that. It's finna be 12 o'clock. Salute to everybody on YouTube. Tomorrow we'll have the follow-up. Tap in, turn on them notifications. Southern Force, salute to you. Good looking. We out.